So with that said, I want to now turn it over to Alan Schwartzseid, who is our managing attorney, our managing partner over at the Orlando area office over in Winter Springs. Alan, please take it away, sir.
All right. Thank you, Jeff. And thank you, of course, to Sentry and Michelle, especially for having us here today. So we have a couple slides to get through, and you should be able to see my information on the screen here. I'll spend about 2 minutes going through who K-Bender Rembam is, what we do, and then we'll get into the meat and potatoes because, frankly, we have 200 slides to get through, and I'd rather get through them than waste your time with some kind of promo. So K-Bender Rembam been around since the 1990s, very early 1990s. We've currently got 21 attorneys, 8 of whom are board certified in condominium and plan unit development law, which is condo and HOA law. That includes me. We have also one attorney. If you've got any kind of defect issues or construction problems in your community, we've got a board certified construction law attorney on staff as well. We do nothing but representing HOAs, condos, co-ops, and these types of community associations. Been doing it since the dawn of time almost. I've been with the firm, back with the firm. I was here for 4 years and I've been back for a little over 2 years. But there are attorneys with the firm that have been here 20 plus years. In addition to our partners, you are basically getting the experience of 35 plus year attorneys, regardless of who you work with, because of our internal peer review system. I don't think you need me to go through every little facet of our practice, but if you are not with an attorney now, we do not require monthly minimums, annual fees, or upfront retainer payments. So if you are not with an attorney now, or if you're not happy with the attorney that you're working with, I welcome you to give me a call or just fill out your survey, like Jeff mentioned a minute ago, and indicate that you like me to give you a call. If you say, yes, please have an attorney contact me, it's going to be me. So moving into the actual materials, let's get started. Why are we actually here today? Well, within 90 days after being elected or appointed to the board, newly elected or appointed directors need to complete this type of educational program, as well as submitting your certificate that Jeff just mentioned you're going to get at the end of this course or sometime after. That certificate is going to be valid for 4 years. So you won't have to take this class again for 4 years. I'd like you to take it so that you get that ongoing education, but you're not required. And frankly, there are other educational requirements that the state has now put in place for HOA directors. That's going to be at least 4 years for communities that are a smaller size, less than 2,500 lots. And if you are 2,500 or more, it's actually 8 additional hours of education every year. At some point, I have a feeling we'll just put on a full day presentation and you'll be done for the day, done for the year. There are certain curriculum requirements that apply to this class and some of the others that you will be taught as part of your board certification, as well as the other certifications that you'll have throughout the year. I'm not going to go through what every single slide says and everything single bullet says, because we have over 200 slides here. And frankly, I'd rather you get through the important material. And especially since we do offer separate classes at no charge online for a lot of these other topics. A lot of them are already pre-recorded for you to watch. CAMs won't get credit for those, but if you just want the education to understand the issues, you can watch those online on our website at kbrlegal.com under the resources tab. So moving forward, if you do not do this class, and you're an HOA director or an officer, if you don't do it, actually just director, I'm sorry, if you don't do it within 90 days after being elected or appointed to the board, you're technically suspended. Now, what that means is you are off the board. It's not a board decision. It's not a, well, but we like John. Too bad. Okay, this person is off the board until they take the class and put their certificate in the business records of the association. Now, the way to get that document into the official records is generally going to be submit a copy to your manager. If you're working with Sentry, I believe Michelle said they'll handle that on their own. You won't have to do anything. But if you are talking about a non-Sentry community, then you would need to submit that to your secretary or your other manager. So that's how you get that certificate in, and you avoid being suspended automatically pursuant to Florida law. Now, that suspended director can have the position filled. That's usually going to be done by an appointment by the other remaining board members. And keep in mind that any actions that that person votes on while they're suspended because the board wasn't aware of this requirement, because you took this class and for some reason they took it with someone who didn't explain that factor, they're still going to be okay. Anything that was voted on, it's not like their vote was illegal, okay? It still counts. It's just not what's supposed to have happened. There's no lawsuit that gets filed. It's just, well, no harm, no foul is pretty much what it comes down to. But make sure that all your directors take a class like this, because really you'll see by the end of these 3 hours or so, there's a lot to learn, a lot to know, and a lot to understand in the operation and the maintenance of a community association. Now, keep in mind, what you're doing as a director is running a business. That's the most important thing that you can understand. You may be a volunteer, you may not be paid for running a business, but you are running a business. Chances are your community is operated by a corporation, a not-for-profit corporation. That's the association, that corporate name that you see all over the association documents, the governing documents, the articles of incorporation. That's the corporation that's running your association. You're on the board of that corporation. So understand you're running a business, whether you wanted to or not. Those educational certificates get maintained for 5 years or as long as the individual serves. Failure to have it, again, does not affect the validity of board actions. That's why I said, if you didn't complete this, that doesn't mean that your vote was invalid. It means you shouldn't have voted, but no harm, no foul. I mentioned this continuing education requirement, so we can skip it. Now we'll get into the meat. We've got Chapter 720. That is the Florida statute governing homeowners associations. So anytime someone refers to Chapter 718, 719, 721, chances are none of that applies to you, okay? Unless you are operating a bunch of communities within a master. Here are some comparisons between the HOA and condo acts. I'm not going to go into detail, but the important thing to understand when it comes to these issues is that a condo is really a creature of statute. The Florida legislature and the Florida Administrative Code are going to tell that condo 90% of what it needs to do and what it needs to know. Whereas in an HOA, there was no HOA Act until a couple decades ago, very recently. And as a result of that, what we're looking at is most of what you're going to look at is what's in your governing documents, your declaration, your articles, your bylaws. So just understand, just because a statute says something doesn't mean that is the law. I know it's the law in Florida. That doesn't mean it's the law that binds your community. So that's a very important thing to note. A lot of spaces, not that you're going to be responsible for reviewing the statutes, that should be your attorney's job. But a lot of places within the Florida statutes will say, unless the bylaws say otherwise, unless the declaration says otherwise. That's not a conflict of documents issue. So if your documents say otherwise, you go with what the documents say in those instances. Where it's not clear, and it doesn't say unless the documents say otherwise, that's where you've got a conflict, and that needs to go through your attorney as well. All right. The purposes of the statute: giving statutory recognition to HOAs, providing procedures, and protecting members' rights with allegedly, now this is where it gets funny, allegedly without unduly impairing the ability of the association to perform its functions. If you've been to a legislative update by any law firm or any management company or anyone else in the last few years, you know that this is complete garbage at this point. There is a direct effort to impair those abilities to actually perform the functions of an HOA. But moving on, before I get too deep onto that soapbox, Chapter 720 does not apply to any of these other communities listed in 718, except to the extent that a provision of those statutes applies. So for example, in dispute resolution, there's a reference to Chapter 718. That portion of the statute will apply. But generally speaking, those chapters governing 718 is condo, 719 is co-ops, and 721 is mobile home parks are not going to apply to your community, presuming you're in the right class. It doesn't apply to commercial, industrial, or other non-residential property or a community composed of property primarily intended for those purposes. All right, so chances are you're in the right place, but just understand there may be commercial parcels in your community. Generally speaking, Chapter 720, the HOA statute, will not apply to those. Which version of the statute applies? This is another important consideration. Generally speaking, the law that was in place as of the date a contract is entered is kind of grafted into that contract. It becomes part of it. So you need to keep in mind your declaration is a contract. It's a contract between the association, that corporation I mentioned earlier, and the members of that corporation. And frankly, anyone else that operates within the association. That could be your tenants. It could be anyone that enters into the association, because this declaration is recorded in the county public records. And everyone is considered to be on notice of what's in the county public records. Okay, so anyone that comes to this is why you can enforce against tenants even though they never agree to be bound by the declaration. Although your lease form should say that they need to agree to that expressly. But back to this slide, you have a right to have contracts that are in place not be impeded by future statutory changes. What does this mean for practical purposes? When there's an amendment to the Florida statutes, for example, the ones that went into place this year, actually, July 1st of this year, that say any commercial vehicle other than a statutorily defined commercial vehicle and any truck can be parked anywhere within an HOA that other vehicles are allowed to park. Now, that doesn't mean they can park on the grass. It doesn't mean they can park in the backyard. So understand, if there is a prohibition against parking in a certain area, that will also apply to these vehicles. I had that come up literally last week where someone said you can't restrict any kind of parking for these vehicles. No, it's just that people are allowed to park them mostly in their driveways, but also anywhere else in the community that those vehicles are allowed to park. That's one example. Okay, that would be a substantive change to a statute. The association had the ability to restrict this before. That's part of the contract that everyone agreed to by buying into the community. And now the legislature is saying, yeah, sorry, you can't do that anymore. Sorry, association. I know you've had the right to enforce this for, I don't know, maybe 50, 60 years. All of a sudden, you can't do it anymore. Well, that's an impairment of an existing contract. So unless you have special language in your governing documents that says we're adopting the statutes, not as they exist today, but the magic language is we're adopting them as amended from time to time. We call that Kaufman language based on a case called Kaufman versus Scheer. Okay, so this Kaufman language, if it's in the declaration, any statutory change is going to apply to you. Okay, the good news, most HOA declarations don't have this language. I'd say at least half of condo declarations don't have it either. What does this mean? Only changes to procedure, which is less of a right, apparently, according to the Florida courts. Only procedural changes to the Florida statutes will act on the association. So what this means is the legislature changed the process for fining this year. That change will apply to everyone, whether they have this special language or not. Okay, the change regarding trucks and commercial vehicles might not apply, but it's up to the board to decide whether to take that fight, potentially all the way up to the Florida Supreme Court, so that someone actually gets it right. My opinion, you'd be right to fight that, but whether it's worth the expense, which could be $300,000, $400,000, $500,000 or more to get up to the Florida Supreme Court and win that issue, it's up to the association. Now, you'd probably have a bunch of people joining you, as they call it, an amicus brief, or basically friends of the court. But I don't see anyone wanting to take that fight that far. If you're willing to do it, yeah, okay, we'll be happy to work with you on it. But the bottom line is there's no guarantee that you get that money back. It's just a matter of setting a precedent. So the lower courts don't really have the discretion to decide those constitutional issues, which is where you have a problem. Anyway, moving on. We talked about a lot of this. We have just some examples of substantive and procedural rights here. So you might want to look at this when you get your materials, but we're going to kind of skip through it real quick. Conflicts between chapter 617 and 720. So I talked earlier about conflicts between the statutes and your governing documents that aren't really conflicts, but some are. Here, if you've got an actual conflict between chapter 617, which is the not-for-profit statute, which, as I mentioned earlier, is going to govern you. Okay, if you are a for-profit corporation, I do have a couple HOAs that are that way, it'll be 607 instead of 617. The law is the same here, though. Okay, the more specific statute, which is going to be the HOA statute, is going to govern those conflicts. Now, another instance that I see pop up very frequently is the conflict that people perceive between the provisions in Chapter 720 that say you need to have an open board meeting for the board to make any decisions unless it can be closed for certain purposes. We'll get into that later. Versus the provision in 617 that says you can have a unanimous resolution of the entire board that's just a piece of paper that all the directors sign and make decisions that way, and that replaces a board meeting. Okay, so there's some people think there's a conflict. There's not. It replaces that open board meeting. Okay, so you can see where someone would think, well, 720 says I have to do it this way. There's no way I can do it any other way, even though 617 says otherwise, and Chapter 720, the HOA statute, will control. But there's no conflict. Okay, so these are things you're going to want to run by your attorney and make sure you get it right, instead of just guessing and hoping you get it right, or relying on your manager whose responsibility does not include giving legal advice. Okay, moving on. Conflicts between the declaration, articles of incorporation, and bylaws. Let's go through what these are while we're going through what order it goes in. And you know what? Good news. We've already shown you what order it goes in because it's right here. Okay, if you remember that old expression, a little dab will do you. Declaration is the D there. That's the declaration of covenants, conditions, restrictions. That's generally going to be what people refer to as your CC&Rs. Okay, it may include easements or some other words, but what we're talking about is the main document that governs your community. It's usually going to have your definitions, your use restrictions, what's the name of the association, etc. That declaration is going to be looked at by a judge with nearly complete lack of discretion. Meaning, let me put that in plainer English because I fumbled a bit there. In other words, the judge is going to look at that and say, yeah, it's probably fine unless there's Florida case law that says you can't do this. So for example, I was actually involved in removing language from a declaration that says that no Jews or blacks may reside in this community. Okay, that's not going to be enforceable even if it's in there, but better to have it out. So if that's in the declaration, it's not going to be enforceable. A judge is going to say, no, this doesn't count. But almost anything else, including taking someone's home because they didn't pay assessments to the association, is allowed. Think about how absurd that is. They could be $100 in debt in principal and lose their home over it. And the reason that's allowed, even though it might be absurd to some people, is that the declaration is always going to predate every deed. What does that mean? You bought in this property knowing you could lose your home over that $100. Now, whether the board chooses to go that route or not, frankly, what I would suggest is set a procedure, have a written document that says, here's how we're going to collect assessments, and have it based on a specific minimum dollar value or a minimum time frame that they've been delinquent. What I see a lot of times is we've got a $100 minimum or a $300 minimum, and if it's less than that these people owe, we won't go after it. Well, that guarantees that people are just going to keep a $300 running balance, and you're going to have a whole bunch of people that owe a bunch of money and nothing you can do about it until you change that written policy of the association. All right, so moving on, your declaration is the top dog here. Your articles of incorporation are generally a document that says what the name of the corporation is, the purpose for which it was created, and usually very little else. There's not a lot else that goes into it, but that document is next in line. Finally, we've got your bylaws. That's usually going to be something that's looked at a little more closely by a judge if a judge is reviewing. And it's basically going to say, here's how the directors are appointed or elected. Here's who they can be. What are the qualifications, if any? How is the budget created is usually going to be in there. Who are the officers? What are their responsibilities? And a bunch of other information. Now, first, let's go through what are the officers, what are the directors, and who are the members. Members, because these are all completely different hats that some of you may be wearing all three. Okay, a member, just in case I use that term going forward, that's literally the people that own property in your community. Okay, it's very simple. And your declaration almost entirely will say, in almost every instance, these are who the members are. It's the people that own property and the developer until the developer's out. If you have a provision that says the developer is a member permanently, that's something you should be discussing with counsel to try and get that taken care of. Because I have 3 that I'm dealing with right now who the developer just decided, you know what, I'm going to have a permanent role in this community, no matter how many properties were sold, even if it's 100%. So we don't like that. Moving forward, you've got your directors. These are the people that vote on almost everything and make almost every decision for the association. Okay, so you've got directors make motions, second motions, vote on motions, or abstain from motions. That's literally the director's job, but it's one of the most important for your entire community because those are the people that make your decisions. Now, people think the officers make the decisions. No, officers do not vote except if they are also members voting as members or directors voting as directors. Officers are just the people that are the president, the vice president, secretary, treasurer, whatever the roles are that are established in your bylaws. Now, the good news for those officers is that if you've got a manager, especially a qualified manager like the ones they have at Sentry, you are not going to have to worry about doing your job because chances are they're going to do it for you. You may have some minimal effort that you need to put in at some point. All right, so moving on to some of the other documents that might govern your community. The board generally gets to establish rules, regulations, architectural criteria, etc. Now, these need to be supported by the other governing documents primarily because they're created directly by the board.
Hey, Alan, I'm going to interrupt. Are we still supposed to be on the dabble do you slide?
Yeah.
Okay. Folks, those of you in the Q&A, we're still on the same topic. Thank you.
Okay. Yeah, just listen along. I'm looking and making sure we're on the right slide. Don't worry. So the rules and regulations, the architectural criteria, these all need to be supported in these other governing documents. And when a judge takes a look at these, the judge is going to scrutinize them a lot more closely because the members didn't actually vote on them. Okay, so make sure that if you're creating rules and regulations, you're creating policies, you're creating architectural criteria, have your attorney take a look at what you're proposing before you actually adopt it and make sure that it's something you actually have the authority to do. Because if not, then you've got a bunch of unenforceable rules and you lose credibility with the members when you try and enforce something and a judge basically eventually tells you, sorry, you can't do this. Now, hopefully you've authorized your attorney to review those rules and make sure that they're enforceable before they're being asked to send out demand letters to have people cure these violations. But if not, you might be getting yourself in trouble without giving your attorney the authority to actually make a determination of whether or not you'll win this case. All right, moving forward, member meetings. The annual members meeting is basically the election. That's pretty much what you're supposed to be deciding. A lot of times you'll also hold all of your amendment votes and things of that nature for this meeting. And the purpose of that is to save money because you need to actually send out a notice for this meeting. Whereas many others, you can just post a notice. So this is going to happen once a year, hopefully. If you're doing it more frequently than once a year, that's probably because something went wrong throughout the year. But it's annually at a time, date, and place stated in or fixed in accordance with the bylaws. A lot of times I'll see in the bylaws that there's a specific date, on the third Monday of every November, you have to hold your election. Please work with your attorney on amending that to expand it and give you a little bit more leeway and not make it so critical that you have it held on that particular time, date, location. I haven't really seen judges enforcing that time, date, location as long as you do your best to have a time and a date that's close to it. But why take the risk? Spend the money fixing this up instead of spending the money defending a baseless lawsuit or a baseless claim by an owner. The election needs to be held at or in conjunction with the annual meeting. And then any meeting that is a member meeting that is not the annual meeting is called a special meeting. It's done the exact same way. You just might have different things that are decided on during that meeting that wouldn't be decided on during the annual meeting. The difference there is that the members can't really call a member meeting except a special meeting by putting together 10% of the total voting interests in a petition saying we want the board to decide on we want to hold a meeting on this particular issue. If you can get that 10% in a petition signed by those individuals, then you can force a meeting to be held. All of the meetings generally need to have an agenda, except that the annual meeting does not. Okay, so every meeting of an HOA, except the annual meeting, needs to have an agenda. My recommendation, though, is to have an agenda even for the annual meeting. The reason for this is, presuming you've got a good policy in place, this is number 2. Remember, we mentioned collection. This is policy number 2 that I think every community association in Florida should have. You want to make sure that members are limited to speaking on agenda items and that they're limited to the 3 minutes that the Florida statutes provide. I've got someone arguing right now in a community that we work with saying that they're entitled to 10 minutes pursuant to Robert's Rules of Order. Okay, well, if you've got a 200 member community and even half of them show up and they're trying to get 10 minutes apiece, good luck getting any business done. So bottom line, yes, have an agenda. Make sure that you've got a written policy governing member participation at meetings that dictates that they get their 3 minutes on each agenda item so that you can limit how long that meeting could possibly take. Moving on, notice. So you do need to provide notice of every member meeting. It needs to state the date, time, and location of the meeting and be sent at least 14 days in advance. Now, if anyone has agreed to accept electronic notices of meetings or electronic notices in general from the association, those can be emailed to those individuals instead. You don't have to have every single member of the community opt into electronic notice before you can start taking advantage of that cost savings and sending those emails out. You just track through a list who has agreed to accept notice via email, send a blast to all those people, and who has not agreed, and you send a mailer to those people. You need to keep evidence that you've complied with that 14-day requirement in the association records in the form of an affidavit signed by the person that sent that out. Again, that's either going to be your secretary, or if your manager is doing it, they're going to create that and get it into the official records of the association. But again, you need an affidavit for every single member meeting that you have. Okay, we talked about electronic notices. Those electronic addresses, by the way, email addresses, fax numbers, those are official records of the association, meaning that any member can technically access that email address, that mailing address that's been designated for the purpose of sending notices. Keep in mind, it's not mentioned in the statute, but if you designate an email address for just email blasts and not official notices, that is not a record of the association. That is something that gets produced when someone asks for all of that information. Okay, only the board and management get that information. So there's a distinction. If it's just for email blasts, which are just unofficial notices of what's going on, that's not an official record. If it is for purposes of mailing out meeting notices and things of that nature, then it needs to be produced. Your manager should know this. If they don't, they should contact your attorney to make sure that they're not failing to produce records that should be produced. You can use broadcast notice. I'm not going to go through what that means because I don't know of anyone that uses it that doesn't have a long-standing policy of doing it right. If you're doing that, you might want to run it by your counsel to make sure you're doing it right, but we're going to skip the rest of that. Website posting is an important one. So if your community has 100 lots or more, by January 1st of this year, you need to have a website where the agenda for every meeting is posted and the notice is posted at least 14 days in advance. You also have to have any contracts or other documents you're voting on that website at least 7 days in advance. Remember, this is for member meetings. Board meetings are separate. We'll talk about those later. Okay. So again, this is a brand new requirement by January 1st. It kicked in July 1st. By January 1st, if your community has 100 lots or more, you need to have a website. Now, most communities that are managed already have a portal in place. So what that means is your manager, and I know Sentry is capable of doing this, you need to ask your manager to put a page on the front somewhere that complies with all of the other requirements that the Florida legislature has put in place for this website, and that will take the place of hosting a brand new website. You don't have to start from scratch. You just need to contact your manager. If you don't have a manager and you don't have an email portal or something where you access all the association information, your ledger, your records, etc., then you'll probably need to create one. Okay, and again, 100 lots or more due by January 1st of this year. What that also means is that until then, you technically don't have to post all these things on the website. I'd recommend doing it anyway, because then you're already in practice when the requirement kicks in and you don't forget. The other thing that I didn't mention, I mentioned that front page that you have to have. On that separate front page, you need to have either a link to every notice and agenda, or preferably just a link that is labeled notices that links to all of these notices and agendas for upcoming meetings. Okay, so that needs to be in plain view on the homepage. Members, as I mentioned, have the right to attend all member meetings and speak at all member meetings regarding all items open for discussion or which are on the agenda. So that's why I say limit your discussion at the meeting as a board or whoever is presiding over the meeting to what is on the agenda, so that you're not opening that up for every other member of the community to have their 3 minutes. You need to give at least 3 minutes, but this is limited if you have a policy in place. The association can adopt written rules. Meetings must be held at a location accessible to physically handicapped persons if requested by a physically handicapped person who has a right to attend the meeting. So keep in mind, the most important part here is if it is requested. You don't need to all of a sudden decide to change your procedures because Alan mentioned that we need to do X, Y, or Z. Okay, if it's related to a disability that you're receiving a request, that's called an accommodation of your rules, that person needs to make the request. You don't automatically have to provide that accommodation without it being asked for. Now, the other thing that many directors don't realize, any owner can tape record or videotape member meetings. Your written policy should say that they cannot, however, interrupt the meeting by running around with their cell phone like this, getting in the face of every person who's speaking so that they have the best possible record. They need to be directed to stand out of the way, out of view, and possibly in the back of the room so that they can record. They're allowed to do that, but they're not going to interrupt the meeting or distract everyone that's in the meeting. And again, just put it in a policy. The board gets to adopt those policies, and then you're done. Your attorney should be preparing this for you. Quorum, unless there's a lower number provided in the bylaws, a quorum, meaning the minimum you need in order to hold a meeting, is 30% of the total voting interests. If you have a higher number, you do not need to have that higher number. This is one of those, it doesn't matter what's in your governing documents. Okay, if the number is lower, you go by the bylaws. If you have no number, or if your number is 50% to reach a quorum, you go by 30%. The majority of the voting interest present is what's going to be the deciding factor. Okay, so if you're voting on XYZ item at this member meeting, all you need is a majority of those people present, unless the governing documents say you need a different percentage. For example, amending your governing documents, unless you've already amended them to make this easier, which is a project we work on all the time, but they may say you need 2/3 of the members to vote on any amendment in order to adopt it. That's still going to apply regardless of what this says. Moving on, proxies can be used to vote. You can also vote in person. To be valid, the proxy needs to be dated, include the date, time, and place of the meeting, and be signed by the authorized person who executed the proxy, meaning I'm signing off confirming that I'm giving you my right to vote on my behalf. The proxy is only affected for that specific meeting. That meeting can be continued for up to 90 days, and that proxy is still good. It is not good for a meeting on a new issue on a new date. Okay, if it's the same meeting that's just being rolled over to a new date because a quorum wasn't attained, that's fine, up to 90 days. Okay, so what you're going to want to do as an association to try and get these things accomplished is make sure that any continuation and adjournment of the meeting takes place less than 90 days after the original date. So do it now, 30 days from now, another 30 days from now, and then another 28 days from now to make sure that you're doing your best to have those proxies remain in place so people don't need to go out and sign a new one, because in reality, most of them won't. These proxies are revocable at any time by whoever signs it, meaning I want to come in and vote in person. You can't vote on my behalf anymore. That's totally okay. Any proxy holder can appoint someone else to use that proxy. So go ahead, Jeff.
Oh, I was waiting for the end of the slide. I'm sorry, sir. I just want to ask your clarification because a few people have now posed this question, okay? If a board member has had continuous service and already took an HOA board member certification class prior to July 1 when this new class became effective, do they need to be here for this class?
They need to take it by June 30th of next year. So they've got plenty of time to take it. My guess is we'll be teaching this thing monthly from now on.
All right.
But and I'm
Thank
sure
you.
Sentry will have several more between now and then, possibly even with us. But
Right.
yeah, they will have to take the class, but not immediately.
Okay. Thank you.
You're welcome. Um, Proxies are revocable, I mentioned. You can appoint. A copy can be used if it's a complete reproduction of the original. So what that means is if you're leaving off some of the text that was on the proxy form and it's a copy, that copy is no good. If you're using orange paper for your original proxies and you reprint the entire content of that proxy after it's signed onto white paper, that will be fine. Okay. General proxy says vote however you want. Limited proxy says you can vote this way on these issues. Limited and general can be used to establish a quorum. Generally, limited proxies are going to be all you can use to actually vote in an HOA. The use of internet-based online voting systems needs to be established by a board resolution at least 14 days before the election or before the item that's being voted on by the members. Now, I'm not going to go into detail about electronic voting. What you really should be doing is contacting your manager, your attorney, other vendors to get a good e-voting vendor and make sure that they are capable of doing everything that the statute requires. And what you would normally do is have your attorney prepare all of the documentation so that the vendor is signing off and acknowledging, yeah, we can do everything the statute requires. There are a couple really good vendors out there. I won't go into detail about any of them in particular, but just understand electronic voting is a fantastic thing for many community associations. The cost in some instances is not even that much more, if anything, than what it would cost you to just do your mailers. And this will also help because you'll have the electronic voting vendor hopefully going out and doing your work for you to get people to opt in, which can now be done electronically. In other words, you can just sign a form online now and opt into electronic voting. The good news with that is also, we talked about electronic notices earlier. Usually you'll have your opt into electronic voting, and the vendor will also ask people to opt into electronic notices. So you may be avoiding a lot of mailing that was required before, but is not anymore because there's a large adoption rate for this electronic voting. What it means, in case you have never used this or heard of it before, is that people can vote on their computers, vote on their phones, and it takes about 30 seconds to go through the entire thing. Your electronic voting vendor will set up the website or the application that's required to enable them to do this voting. A lot of times it means that you don't need to have a meeting. You just have these people take care of the electronic voting if everyone opts in, and you can set it up so that you have the choice to either vote this way or sign proxies. And if you have a provision in your bylaws that says you're allowed to vote from the floor, you can get that removed by an amendment so that you never actually have to have the meeting, other than basically showing up and counting the ballots. Now, the other nice thing about electronic voting is that the vendor counts those portions of the ballots for you. You don't need to physically count them. You'll just get a report of what the count was, and the vendor will maintain that data. One thing to note is that all of these election records need to be maintained for 1 year after the election result is announced. So you'll need to get that data from the vendor. They should know to get it to you, but just be aware this electronic voting can be very helpful. And again, I don't see the need to go through it in detail, but make sure that you work with a good vendor and preferably a good manager and attorney to make sure that they're doing what they need to do. Okay, election is what we're now talking about. Vacancy that's caused by the expiration of a director's term, meaning you termed out, must be filled by the election. If there's nothing in the governing documents that specifies how long the term is, it's 1 year and everyone just gets voted back in every single year. Elections are held at or in conjunction with the annual membership meeting, like we said, or as provided in the governing documents. They need to be conducted in accordance with the procedures set forth in the governing documents. Usually that's going to be the bylaws. Okay, so you're going to look at your bylaws and see what does it say about elections. Now, if it's in the declaration or the articles, just understand that's a little bit out of the ordinary, but it does happen. So just know that you are actually complying with those requirements. What you may want to do is have your attorney create a little guide for how your election is supposed to run. What notices are required? What's the timeline? How is this going to work? So that you don't need to try and refer back to the bylaws and interpret the legalese that's in there every time you have an election. You just have this guide and you use it every year. And unless the Florida statutes change something, you're good to go. Unless the governing documents say otherwise, you do need a quorum to conduct an election. That's not the case in a condo. You just need a certain percentage. But in an HOA, understand, you do need to have a quorum in order to have an election. If you don't have a quorum, that just means that the former directors roll over. They stay in place for another term or another year. Unless otherwise provided in the governing documents, the majority rules is really what this comes down to. Whoever gets the most votes wins. Any member is eligible to serve on the board unless they're otherwise disqualified. There's a bunch of things that'll disqualify you if you're delinquent on the last date that you could be nominated for directorship. That could be the date of the election, depending whether you allow nominations from the floor. A person that was convicted of a felony in Florida or a U.S. district or other territory that would have been a felony if it occurred in Florida and hasn't had their civil rights restored, meaning they've been out of prison for at least 5 years, is not eligible to serve. Person with pending criminal charges pertaining to an HOA, a condo, or a co-op is not eligible to serve. And when I say pending criminal charges, I don't mean John down the road said that Jim stole money. I mean, there was actually a prosecutor willing to take on the case. A member may nominate themselves as candidates for the board at the meeting if the bylaws allow for that. And if the election process doesn't allows candidates to be nominated in advance, you don't have to allow nominations from the floor. So you have two different ways of doing it. One is allow nominations from the floor. The other is everyone's nominated in advance. You've got ballots prepared just like in a condo, and everyone checks some boxes. Election by acclamation is what happens when there's not enough people to require an election, meaning there were 5 spots open, 4 people put their names in the hat, or 5 people put their names in the hat. Why would you go through that entire process of having an election when you know that all of those people are just going to win anyway? So acclamation is basically, yeah, we don't need the election. We held the meeting. We had a quorum. The 5 people that put their names in the hat are now the directors. Done. If you have to have an election, people can vote in person or by proxy unless the governing documents say otherwise. You can have secret absentee ballots. In that case, you basically follow the condo procedure, and we do have an election class that goes through that in detail. I'm not going to bore you with it now. But any ballot or any vote received after the closing of balloting cannot be considered. What that means is make sure that you make an announcement. We are closing the balloting sometime after the meeting starts so that you can actually start counting those ballots without worrying about someone submitting their ballot afterwards. And then anyone that submits a ballot after that announcement is made, that ballot doesn't count. What I would suggest is make sure that it goes on the notice what time you plan to cut off the balloting. That way everyone is notified in advance. They don't argue, well, you cut it off 15 minutes after you started the meeting. I couldn't get out of work on time, so I wasn't able to vote. Well, you could have submitted it via proxy, so I don't want to hear it, but you're still going to hear it. So bottom line, I would suggest putting something in the notice that indicates when you plan on closing out the balloting. And again, unless the bylaws say otherwise, you have a 1-year term for every director. Any challenge to that election process needs to be raised 60 days after the election results are announced. Otherwise, it's waived. And these election disputes generally can go to binding arbitration with the division or filed with a court. Now, generally speaking, if it goes to the division can decide however the heck they want. The courts are generally going to follow the law. And I don't say that flippantly. There is literally case law that says arbitrators are allowed to be arbitrary. in their decision making. And the ones that work with the DVPR, some are fantastic and some are extremely arbitrary. Not to mention the fact that you lose at least a third of your prevailing party fees because the arbitrators use extremely low dollar values for what attorneys are worth per hour and tend to cut the rates for absolutely no reason in my perspective. Officers, remember, difference between election of directors by the members. The officers get elected by the directors. So you should be having your election of officers at a separate meeting of the board that can be held immediately following that election meeting. You can either be appointed or elected by the directors, and the directors can't vote in general by proxy or secret ballot at board meetings because it needs to be open. The only change to that is if it's confidential for other reasons that we'll get into later, or secret ballots can be used in electing officers. There's no prohibition against changing the officers midstream. What does that mean? If an officer decides that they're going to go out and send a bunch of violation notices without the authorization of the board, they're going to walk over to someone's house and knock on the door and say, hey, I'm the president of the association, and I want you to go ahead and comply and mow your lawn because I'm tired of seeing this. Well, that action was not taken at the discretion of the president because the president has no discretion to make those actions unless the board has decided that the president should go out and do it. So there should be no officers that are taking actions that haven't been authorized by the directors. Those don't need to be the same people, officers and directors. Okay, so we talk about, does the president vote? No, we talked earlier about how the directors and officers are different people. The president is an officer role. Director is a director role. So when people say the board president, even people within our firm say it. I don't think that person exists. It's the president or a board member. Okay. Fraudulent election voting activities. I really hope we don't have to go through this, but if you commit fraud in the election by changing a ballot or doing something like that, or asking or pushing or pressuring or forcing someone else to do it, that is a first-degree misdemeanor. Keep in mind, and this is also threatening other people to vote in a certain way, using or threatening to use, etc. So this is all election fraud. I hope you know what it is. Feel free to take a look at the slides later. If you're intervening and interfering with the way someone might want to vote or the way that they intended and tried to vote, that might be election fraud, and it's not really ideal. The difference that started in July of this year is that knowingly aiding, abetting, or advising someone in committing a fraudulent voting activity is also now a crime. So it's almost just as bad. So just make sure that if you know that this is going on, see this last slide, giving any aid with the intent that the offender avoids escapes detection. What that means is you knew about it and you said nothing. Because if you don't say anything, you are aiding them in getting away with it. So bottom line, if you know someone is doing these things, bring it up, preferably to your manager or attorney. If you are doing them, stop now. And beyond that, just read through the slides if you can. Vacancies on the board might arise. In other words, there was someone on the board, they're not on anymore. Either they were removed by a recall, which will be discussed later, or it's before the expiration of a term, so you're not just doing an election. You have the option of either having an election, I don't know why you'd waste your time to do that, or preferably you just appoint someone. That appointment gets done at a board meeting where the directors vote to say, we want this person on the board. Even if there's only one director left on the board, that person can appoint other people so that you're repopulating that board to where it's supposed to be pursuant to the bylaws. And someone appointed to fill that vacancy serves the rest of whatever the term would have been for the director who's no longer on the board. Okay, so what is the board? Board voting. The officers and directors have a fiduciary responsibility to the owners, and in reality, that duty is to the membership as a whole, not any individual, really. Although those individuals can still sue you for violating that duty. Now, what is the fiduciary duty in the first place? It essentially means that you need to do what is in the best interest of the association, even if it hurts you. So this is one of the highest duties imposed by law. You're basically a trustee of the association. The good news is, even though this is that highest duty imposed by Florida law, it's judged by what I like to call the dumbest guy in the room standard. What does that mean? It's judged by the reasonable business judgment of the directors. If you reasonably thought, now reasonable is where it gets a little hairy here, because it's not really the dumbest guy in the room. It's, was it reasonable to believe that what you're doing is in the best interest of the association? You're generally going to be protected from personal claims. Now, there are other things that you might see, such as, okay, that might be protected by an indemnity provision in your governing documents, etc. But just understand, in general, you have a very high duty to your membership. So you got to make sure that you're doing what's in the best interest of the association. Now, unless otherwise provided in the governing documents or Florida law, the association's powers are exercised by the board. What does this mean? Unless something says in the governing documents or Florida statutes that a member meeting is required in order to vote, the board gets to make the decision. This is why I say the board makes most decisions for the association. We talked about this. Directors can't vote by proxy or secret ballot except electing officers. And directors, this is important, directors can use email as a means of communication, but can't vote on association matters via email. So the way that, I hate to put it this way, but the way around this is the unanimous consent that I mentioned earlier. The unanimous resolution, all the directors agree on it. It's not going to make a difference what any member might point out. We're going to decide this way. We really liked Alan's presentation. We're going to hire him regardless of what any member of the community might say about our current counsel or their cousin John, who also is an attorney but practices in New York in criminal law and shouldn't really be hired by the association. If it's not going to make a difference what the members say, you can use this alternative method. Now, the other thing that the board can do in lieu of having an open board meeting to make a decision is make the decision, act on the decision, and then ratify the decision by holding that full discussion and voting on the issue at the next board meeting. Neither of those latter options is the preferred option. Okay, the statutes are very clear that the preference is to have a decision made during an open board meeting, but there are alternative options available. So what is a board meeting? It's when a quorum of the directors meet, so usually that's a majority, to conduct association business. Whether that's intentional or not doesn't matter. If you're making decisions, it's a board meeting. Now, the question that a lot of people ask is, well, what if we know we're not making decisions beyond there were 10 bids and we don't even want to consider 7 of them. We want to narrow it down to that 3 that's left. That's like a workshop, right? Okay, well, there's no such thing as a workshop in Florida law. You either have a board meeting or you don't. Some people will say if you're only considering options, and I'm one of them, that is not conducting association business. You're not voting on anything. You're not deciding anything other than this is not even an option at this point. Okay. Some people will say if you are deciding what is and isn't an option, that is conducting business. It's the decision of the board. It needs to be done in an open board meeting. So my suggestion is if you're going to make those decisions, pass a resolution unanimously that these 7 options won't work and you're covered under Florida law. Okay. So I used to kind of say, well, don't worry about it, just move on. But no, I think the safer option, if you're going to look at it as this wasn't a board meeting, but you made some decisions to not work with someone, you don't have to put the rationale behind it into that resolution, but put a resolution together, and then you don't have to worry about whether it was or was not a board meeting because that resolution takes the place of a board meeting anyway. All board meetings need to be provided with 48 hours notice. It needs to be posted in the community in a conspicuous location, except in an emergency. So a hurricane might have been an emergency. It's probably not anymore unless you're in one of those areas that is still in a state of emergency within Florida. And if you are, I am very impressed that you're spending 3 hours with me today. So thank you. The notice needs to include the date, time, and location of the meeting and specify all agenda items. Remember, you have to have an agenda for every board meeting. I mentioned that earlier. Assessments can't be levied at the board meeting unless the notice specifies that assessments will be considered in the nature of the assessments. My opinion and the opinion of the firm, to my knowledge, is that that includes your budget meeting. So that's a 14-day notice of a meeting discussing the budget. Why take the risk, provide the extra notice, and move on with your day? The other thing to consider is if your bylaws require longer notice, you should maybe provide it, but also you maybe should be working with your attorney to amend that provision of your bylaws to provide the same notice that's what's in the statute, because that's a procedural issue. If it's for a vote on a special assessment that you're holding a board meeting, or changes to use of the lots themselves, not policies, not changes to the way you use the pool or the gym, changes to use of the lots themselves, that is a 14-day notice. And if it's a special assessment, you need to specify that it's a special assessment that'll be voted on, the nature and the dollar figure and the anticipated due date of that special assessment. Now, for the budget, for those special assessments, if you change the dollar figure during that actual meeting, that does not mean you have to renotice it and start from scratch. You just change it and you put out whatever the result was. Now, if you are required to have a website, either way, you can adopt a procedure for conspicuously posting the notice on the website. But note that you'll also need to physically post that notice in the community. And any rule that says that you're going to do this basically requires that you have a hyperlink to the notice itself. Okay, and again, if you are required to have a website, you will be required to post this on the website. You won't have the option to do it. Member participation at board meetings is exactly the same as member participation at member meetings. So that's why when people ask me to create these policies, I do them as a set of 7 or 8 that we'll get into later. But the first 2, I mean, this one, it's literally just member participation at meetings. Doesn't specify whether we're talking member or board because you treat it the same way. Recording and handicap access are the same. Compensation. Generally, directors, officers, and committees can't be compensated unless the governing documents say that they can, or you are being basically reimbursed for something that you came out of pocket and it was an appropriate association expense, or everyone else in the community is, also recovering that same dollar figure from, let's say, financial benefits from some investment the association made, or a lawsuit was resolved, or insurance proceeds came in, etc. In addition to no compensation, generally, you cannot accept a kickback or solicit a kickback. What does that mean? If you want to work with me, you can't say, well, if you buy me dinner at Ruth's Chris, I'll work with your firm. I can buy you that dinner, but you can't accept it. And as a result, I'm not going to buy it for you and get you in trouble as the person that you're considering hiring as your protection from legal claims. But keep in mind, and by the way, this is a 3rd-degree felony if you accept a kickback. So again, don't do it is really the rule, but an officer, director, or manager can accept food to be consumed at a business meeting with a value of less than $25 per person. So I'll be happy to take you to the ale house instead of Ruth's Chris. Service or good received in connection with trade fairs or education programs. That's where you go to the CAI trade show. You go to the CAMU trade show. You go to the Orlando Condo and HOA Expo. Those are the types of events where if we're giving you things there, and it's generally going to be pens, pads, folders, the little stress balls that I love throwing at Jeff, things like that, those you can accept because it's in connection with a trade fair or education program. Let's see, grounds for immediate removal. If you do any of these things, you are off the board. Now, I don't mean just do it, but again, you're charged by a prosecutor by information or indictment, which are criminal law terms that basically say you've been charged with a crime. You are off the board immediately. This is forgery of ballot envelopes, theft or embezzlement involving association funds or property, tampering with physical evidence, destruction of records to avoid incarceration, obstruction of justice, or any other criminal violation under the HOA Act. Now, the board needs to fill that vacancy until the end of the period of the suspension. The suspension is going to end if that person is found not guilty because the criminal trial is completed or the charges are dropped during the term that was already in place. If by the end of that term, that person's charges have not been eliminated or addressed, or they're found guilty, that person that was appointed carries over to the end of the term. You have your normal election at the end of that term. And if you already have one of these criminal charges pending, that's one of the other things that will disallow you from being a nominee for directorship. Let's see. Also, if you're more than 90 days delinquent in payment of any monetary obligation to the association. Now, keep in mind, this is not in a condo. So for my managers that are here that represent both, what we're talking about is more than 90 days delinquent in any dollar figure. It could be fines. It could be you didn't pay your rekeying fee. That was $50. You're off the board automatically. This is another no vote, and it is not a suspension. It is treated as abandonment of your role as a director or officer. So what this means is that you are off the board entirely, and the board can fill that spot. Now, once you've paid what you owed, the board can go ahead and fill that spot with you. But what I was getting at with condo, there is no requirement to notify the person in advance. There's no minimum dollar figure for this. So they could, like I said, they could owe $50 for rekeying charges. No notice was provided, but they're still off the board. Conflicts of interest are a subject that I actually spoke to a group of attorneys about less than a month ago. And it is a major issue primarily in South Florida, but it happens everywhere. And these laws apply everywhere, so you need to know about them. If you are trying to do business with the association, or a company that you play a role in, or your family member plays a role in, wants to do business with the association, that is 100% okay. The fact that you're on the board, the fact that you're an officer, the fact that you're a manager does not mean that you can't do business. It means you've got additional disclosure requirements. Okay, and that requirement is basically notify the board and the other people that'll be voting at least 14 days in advance of the vote being taken. You need to step aside when that issue is being discussed, although you can present it on behalf of the company or on behalf of yourself that's looking to do business with the association. Step aside during the vote as well, meaning get out of the room so that there's no interference with that vote. And 2/3 of the remaining directors need to vote in favor of that contract or that service. So there are big requirements. There is a rebuttable presumption that there's a conflict if a director or officer or relative of one of those people enters into a contract directly or offers to do business with the association. Okay, we talked about this. Now, the other thing I didn't mention, at the next, not any, but the next regular or special member meeting, usually that's going to be your election, the members get to vote. The existence must be, the existence of this conflict and the contract must be disclosed, and the members can vote to cancel by majority of the members present at the meeting. Okay, so if the members cancel the contract, the association is only responsible for whatever goods and services were provided up through the date of termination. Now, that doesn't mean up through the date of the vote. You still need to give notice of the termination. But once that notice is given, which should be like the day after that vote is taken, there's no other liquidated damages regardless of what's in the contract. So just make sure that you disclose all of this stuff the way that it needs to be disclosed, because if not, you're going to get in trouble for it. There's going to be some self-dealing claims. Just make sure that you're taking care of that the right way. Doesn't mean you can't do it. By the way, conflicts are not always bad. Okay, I know plenty of communities where the cousin got the association a fantastic deal on landscaping services. That doesn't mean it's bad just because there's a conflict. All it means is you have disclosure requirements. By the way,
I'm glad you clarified that because that's how good ideas are born. Like when you have something that has been in existence for a long period of time that doesn't seem to make, I wanted you to have that water. I could hear your voice. So when things are challenging for a long period of time or stagnant or in a stalemate, sometimes these conflicts are or give, birth to new ideas that further enhance the association. So anyway, back to you.
yeah, thanks, Jeff. That's a good point. And the other thing I want to bring up regarding conflicts is that you don't have to choose the lowest bid on any contract for the association. You choose what's best for the association. And the fact that that nephew, that cousin, whoever it is is slightly more expensive or even a lot more expensive doesn't automatically mean that that was a bad choice by the association or by the board. Committees, unless the articles or bylaws provide otherwise, there are two different types of committees. One's created by the board, one's created by, one is an advisory committee that tells the board what they think the board should do. Fining and use right suspension committees, architectural committees, and organizing committees for covenant revitalization are not subject to these requirements. Okay, the same meeting requirements to have open meetings, etc., apply to meetings of any committee when financial decisions will be made regarding spending association funds. Those are usually the advisory committees, or an architectural review decision is being made. Okay, meaning those meetings need to be open to the members, generally speaking. Now, again, this doesn't apply to certain committees that are listed in this second bullet here. All right, official records. This is basically, I'm going to skip through the first list because it's everything that you would think goes into the official records and all other written records of the association that are not specifically identified, which are related to the operation of the association. So basically, anything that is written and pertains to the operation of the association gets maintained in your official records. Period. End of story. This catch-all is directly in the statute. Now, the official records, so we talked about policies. The new law is that you actually have to have a records retention policy that states how and when are we going to get rid of records if we're going to ever delete them, throw them away, shred them, whatever we're doing with them. You must adopt written rules, regardless of whether you ever intend to destroy them, stating how and when you'll do that. So this is policy number 3 and 4. I usually combine them now that this is a requirement. I was suggesting people do it before. Now I'm requiring it. We're telling them it's required. You got your records retention policy, and we'll get into in a minute your records inspection policy that I think every community in Florida should have. But the official records get maintained for at least 7 years. Note that in a condo, that's probably forever. I see a lot of this things that we're talking about in HOA land being shifted towards the condo style regime, meaning that eventually you may also be required to keep a lot of records indefinitely, meaning forever. So if you're going to get rid of them, do it now before the legislature tells you you're no longer allowed to do that. I'm not suggesting that you want to get rid of your official records. I'm just saying if that's something that you have been doing, put the written policy of how and when you'll do it in place and continue following that policy until the legislature says you can't anymore. Bids received by the association for work to be performed must be kept for 1 year. Election records are also only kept for 1 year after the date that the election result is announced. There is a list of official records that are still official records, but unlike the others, they're not accessible to the members. Only the board, the attorney, and the manager get to see these records. These are going to be your attorney-client or work product privileged in items that are related to either ongoing or future litigation. They're going to be pertaining to the approval of a lease, sale, or other transfer of a parcel. Usually that's going to be your background check information, basically, that doesn't get disclosed to anyone but the association board, including the person that submitted the request. Information obtained in a gated community in connection with guests' visits. In other words, you're not entitled as a member of the community to get John's guest's driver's license. And then we've got a whole list of personal identifying information that is not subject to disclosure. Personnel records of association or management employees. Now, that doesn't mean that the association isn't, required to disclose what the personnel is earning dollars-wise if it's association personnel. Doesn't mean you don't have to provide a copy of your management contract. It just means that those individual employee records are considered confidential. Medical records of owners or residents that you might have gotten in connection with disability-related requests or a personal injury type of case. Any electronic security measures that's used by the association to safeguard data, so your login credentials are not official records. Association software and operating system that allows manipulation of data. In other words, you're going to provide the QuickBooks printout in a PDF or something. You're not going to provide direct access to QuickBooks so someone can change what they owe. And then all affirmative acknowledgments made pursuant to this statute that's mentioned in the last bullet, which pertains to the changes to the way that you're providing your invoices for assessments to the members. Attorney-client privilege. The most important thing to know as a board member is you individually have zero right to break the attorney-client privilege. That's a decision that gets made by the board. The entire group needs to vote. If you break that attorney-client privilege, you have given up the rights of the association to have those decision-making emails, communications protected. The association attorney telling you you have no case and you decided to pursue it anyway is all of a sudden a letter that gets into the other side's hands. Okay. Only the board gets to waive that privilege. Even the attorney doesn't get to waive that privilege. I don't get to send things to a judge or to the other side without you telling me it's okay. Now, a judge might be a different story. That's going to be an attorney by attorney decision, but bottom line, you need to understand that you are limited in how you can disclose this information. Membership directories can be printed and distributed. The owners can exclude their phone number. They cannot exclude their mailing address or email address. They cannot exclude their name, lot information, or physical address. They can provide written consent for you to disclose all of this other information, but anything that they have not agreed to disclose other than their name, address, and lot information, and any email or mailing address that they've provided for official notices of the association is not something the association is obligated to disclose in response to a records inspection request. Okay, rules and covenants. Official records, including the declaration articles, bylaws, and all of those board-made things that I mentioned. You were supposed to have this done by October 1st, either providing a physical or digital copy of association rules and covenants to every member. Now, what that means is hopefully your manager sent out some kind of postcard saying this is available on our portal at wherever. Okay, those are the types of things that we're really looking at. You can also post a complete copy of the rules and covenants on the homepage of the association website, which is what I think almost everyone is doing instead of sending a physical copy of a document book that could be over 200 pages to every member of the community. That would cost a lot of money and be a big, big waste instead of sending a postcard. Access to official records. I mentioned records inspection requests. This is yet another policy that I think every community in Florida should have. Okay, what we're really talking about here is someone sent a written request to inspect the records of the association. You are not required to pull out each individual document and say, here you go. But what you are required now to do is keep those documents organized, have them on the website if you're required to have them, and your response can be all of the documents responsive to your request are located behind the portal that we've set up for all members, or on the website we've set up for all members. If you don't have login credentials, please feel welcome to contact us. Your inspection is complete. That's really all that the association has to do now. Now, if you're going to provide a physical inspection, you need to provide that within 45 miles of the community or within the same county, whichever is closer, or actually either or. And you need to do that within 10 business days after receipt of the written request. Now, keep in mind, the written request doesn't need to be sent certified mail in order for it to be valid. It only needs to be sent certified mail return receipt requested in order to create a presumption that the failure to comply with that 10-day requirement was intentional. So you still need to not ignore that request. And it's even more important now that you don't ignore that request, because this year, July 1st, the Florida legislature actually made it willful failure to comply more than twice in any calendar year, any 12-month period, is actually a crime now if it's in furtherance of hiding records. Also, any member that's denied access to these records, meaning the records aren't simply provided, it's that straightforward and easy. If the records are not provided within the 10 business days, then starting on business day 11, they get a $50 gift every single day for 10 business days. Okay, so that $500 gift is not one that you want to give to these owners who are requesting the records. It should not be that difficult to respond to a records inspection request unless you are trying to determine what records you are not going to provide. Those should also already be kept separate through separate login credentials if they're not records that the association should be providing. That should only be accessible to the board, the manager, and if your attorney has access to your portal, your attorney. Also, regarding official records, if you receive a subpoena for records from a law enforcement agency, the association only has 5 business days to produce this. I don't know who was refusing to comply with these requests, but you must assist law enforcement agencies in their investigation. I don't know, again, why this statute was necessary, but it was put in place July 1st, and now it's a requirement of Florida law. I would anticipate you are already complying with this, but maybe the fact that the 10 business days was not quick enough for some of these law enforcement agencies to get the records and act on them was the problem. I candidly don't know. We talked about official records crimes. If you knowing and willfully and repeatedly, meaning 2 or more times within a 12-month period, fail to provide access to official records with the intent of causing harm to the association or one or more members, you are committing a second-degree misdemeanor. Now, I mentioned earlier, this is the requirement, but what does it mean to have intent to cause harm to one or more of the members? What if someone needs this record to do literally anything that they want to do? Technically, by intentionally not providing it, there's an argument that I anticipate being made that you intended to harm that member. So now all of a sudden you fail to provide these records within 10 business days, twice in 12 months, you have committed a second-degree misdemeanor. I think this is ridiculous, but it is the state of the law right now, and it will probably be enforced. So just be careful. Chances are it's your manager, if you have a manager, that's going to be responding to these. But if you get a records inspection request for some reason and it's not your responsibility to issue the response, get it to your manager that day. If you deface or destroy accounting records or other records of the association to try and cover up a crime, that's a first-degree misdemeanor. And refusing to release or otherwise produce official records in furtherance of the commission of a crime is a third-degree felony. These are super fun, right? Now, I mentioned you can adopt these rules and regulations governing frequency, time, location, notice, records to be inspected, and manner of inspected. There are limitations on what can go into any of these policies. Some of the limitations here are you can't require anyone to show a proper purpose or a reason for the inspection. You just have to produce the records if they're requested by someone who's entitled to them, which is any of your members. And you can't limit an owner's right to inspect the records to less than 1 8-hour business day per month. What does this mean? What we're talking about is limiting it to every 30 days, not per month. Because when you say per month, you get one request on the 30th and another on the 1st. Technically, those are separate months. Okay, make it every 30 days. Again, have your attorney prepare this policy so that it's easier. I do it as a package deal on a flat fee basis for the entire package of 8 policies. If that's something you're interested in, I do have some communities that work with us just to get the governing document book that we create as the first step for every new client and get those policies prepared. And then they end up working with us because they like us. But bottom line, if that's something that you're interested in doing, please feel free to reach out to me. Copying records and fees. And by the way, I didn't mention it earlier, but I do need to mention it now. If you don't have a manager and you're self-managed or you're not happy with your current manager, hopefully they're not already with Sentry, but please really reach out to Michelle because Sentry does a fantastic job. Okay, copying records. You can copy those records using a scanner, a portable scanner, not the association scanner, a portable scanner, a cell phone, a camera, whatever you want to do, that's free of charge. If the records are going to exceed 25 pages, then you can charge up to 25 cents per page, plus the reasonable cost up to $20 per hour for the manager to do the work to get those records together. Now, that shouldn't apply anymore if everything has been digitized. It should be go on the website, have a nice day, your records inspection's done. But if the manager is being asked to make physical copies, you can charge for that personnel cost up to $20 per hour, which is not nearly enough for pretty much any manager that's going to be doing this work, but that's what the legislature thinks is good enough. If the work exceeds a half hour and 25 pages. Okay, the website, we talked about this one almost ad nauseum. You do need to provide some protection. So I mentioned that you need to have a password, you need to have login credentials. You can't just have all of the records up out in the open. What I do suggest, though, is that the official governing documents of the association be made available directly on the front page of the website without logging in. Because the bottom line is, those are public records anyway. There's no reason to keep them behind login credentials. Everything else, yeah, go ahead and put them behind a login wall, so to speak. All of these documents, most of them are the official records, need to go on the website. Honestly, it's easier rather than go through this list to just post all the official records on the website, except the ones that the members are not entitled to see. The other thing, contracts that are pending that the association is going to vote on go up on the website before they are voted on now. So if you're required to have that website, just understand that contract needs to go up before that meeting occurs. Let's see. Associations not liable for knowing, except for knowing or intentional disregard of protected information, either by posting on the website or by producing in response to an official records inspection request. So again, it's well, it wasn't my intention to give out this information. I didn't realize that it was confidential. Now, the statute doesn't define what that intent needs to be. So it could be that I didn't intend to give it out. Well, yes, you did. You provided it. It's on the website. That could be enough to say, sorry, but this doesn't apply. I don't see that happening, but you never know. Moving on, amending the governing documents, which is something I've mentioned several times and a lot of people have no idea how to do. Usually this is something that the members are going to get to vote on. Your governing documents are either going to provide a percentage, but if the documents are silent, you have a 2/3 vote of the members. If your documents are silent and you have a 2/3 vote requirement, again, one of the more popular amendments that we do is to actually change the requirement to say it's a majority of a quorum so that you can actually accomplish these things. Electronic voting can also help you accomplish this. Amendments to the Articles of Incorporation bylaws, which impose a higher quorum or voting requirement than the general quorum or amendment vote requirement, are not required to be approved by a greater quorum. In other words, you can have these lower statutory percentages and take advantage of them if your governing documents say you need a 75% vote. Nope, statute says it's 2/3. The proposed amendments need to be formatted by underlining all new text and striking out all old text. See the second bullet. But if the proposed change is so massive that you really can't tell what it actually says and doesn't say anymore, then you can use this text that's quoted here, substantial rewording, see governing documents for current text. And instead, you basically have a clear one-time statement of everything that's in that provision. My suggestion is that if you're amending for anything more than maybe a 5th time in a row, do an amended and restated, because otherwise your attorney and your members and your board and your manager are having to look through 5. I've got one community that's got 20 amendments and doesn't want to do an amended and restated because they don't think they can get the vote for changes to be made. And they won't do it. So we're sitting here and reviewing 20 amendments. It adds an hour or two to every review project that they want us to do, rather than just going ahead and taking care of that. Now, the other way to take care of that, if you don't think you can get a member vote, is by creating what we call a consolidated set of documents. You're taking the actual original text and all the amendments and making it into one document that is what was already in the documents, but in a single document. What that means is there's only one thing to review, but there's no changes. And because you're not actually amending anything, that is a board-only vote to do the project and save you some money going forward. So even if it costs $2,000-3,000 to put that together, figure you do 5 projects, you're saving yourself money in the long run by making it one consolidated document. So that's another project we work on fairly frequently that a lot of people don't know they can do. And candidly, it's not something I ever heard suggested until I got to K. Bender Remum again. Clayton and McCullough, my former firm, that they just didn't do it. And several other firms that I've spoken with don't do it at all. I think it's extremely helpful to get everything in one set. Moving on. If there is a lender consent requirement, you only need to provide notice to the lender, and only if they are actually impacted by the change that you're proposing. Okay, if you are going to have to provide that notice, it's not that you get the lender to vote anymore. It's that you give the lender 60 days notice for mortgages recorded after July 1st, 2013. You give the lender 60 days, what we call negative notice. And if they don't come back and say, I object to the change within that time, their vote is out the door. It's like they voted for it. It doesn't change anything. You don't have to worry about them anymore. Developers cannot exercise unilateral power of amendment if that amendment would alter the general plan of development. So if you're in an HOA that was supposed to have 20 huge 5-acre parcels, and all of a sudden the developer says, you know what, I'm going to go with 1/3 of an acre per parcel. That's going to be a couple thousand lots, or however many it would end up being. That would be a huge change to the general plan of development. Would probably require a vote of the current members of that community. The effective date is the recording date, and within 30 days after recording the amendment, the association needs to provide copies of the amendment to the members as recorded. If you've provided that in advance, then all you have to send is a little postcard or a letter that says, hey, this was recorded. Here's where you can get it in the county public records, or you can request a records inspection. Not posting that notice or providing that notice to the members after you record it is not going to invalidate that amendment, but it will require that you do it later on, and it's not going to be quite as easy or as straightforward. So that amendment would still be valid even if you didn't provide notice after the fact. You still got to get the required vote in advance. Leasing restrictions, that we have an entire class on this, so I won't go through it in detail, but just understand there are certain leasing and sales restrictions that will only apply to people that voted in favor of it or bought in after that restriction became effective. So the people that are in there and are already allowed to lease their property for however long they want, those people are going to be able to continue doing that unless you use certain statutory protections. That's something you'll want to discuss with your attorney when you're contemplating making those changes. It's something we deal with on a fairly frequent basis. Moving on, and I know I'm blitzing through some of this, but we're at slide 75 and we're at 12:32, and I'd like to be done by 2 o'clock. So we're going to go a little faster moving forward. There are a couple sections we will skip most likely altogether, but we do have separate classes for each one of those, which is why I'm okay skipping them for the most part. Again, no discriminatory restrictions can be in the declaration. The board, without having a member vote, and this is the way I did it when I did it with the no Jews or Black people allowed to live in this community, the board can just vote to extinguish discriminatory restrictions and get them out. That's the same as having a member vote, but for this particular type of amendment to the declaration. Okay, we're going to go through some of this later, so I'll skip it for now. Government filings. Just know that just because you are a not-for-profit corporation doesn't mean you don't still have corporate, state, or federal requirements and obligations. Every year you need to file a tax return, even if you are not paying taxes. And every year you need to file a report with the Florida Division of Corporations and pay a filing fee to make sure that your corporation remains active. Meeting minutes. So it doesn't matter what kind of meeting it was. If it's a board or member meeting or a committee meeting that has to have meeting minutes, this is the way you do it. Who voted? I'm sorry, let me start that over. Who made the motion? Who seconded the motion? How did each director vote? That's it. That's the meeting minutes. It's not paragraphs upon paragraphs upon paragraphs, and it's not a verbatim copy of a transcript of the meeting. It's literally what happened here. That's it. And the easiest way to do that is go through the agenda, see how everyone voted and what was voted on, make notes of that, and then transcribe that into the minutes. Write down the motions that were made, who made them, who seconded it, how everyone voted. That's it. Okay, I see 10-page meeting minutes for a half-hour meeting, and I just cringe because it's not necessary. So you're taking the manager's time and forcing them to take all of this time to type this up, or the secretary's time if the manager's not the one doing it, and you're wasting that time. The other thing that you're doing is giving everyone ammunition if they want to go against the association because everything that was discussed during that meeting is right there. John mentioned that this was a terrible idea because XYZ was the risk. Okay, well, all of a sudden now that's on record instead of the board voted in favor of the thing. If you only have the board voted in favor of the thing, John needs to later prove that he said this and it has some impact. Versus now, when we've already got it in our own meeting minutes saying John said it was a bad idea. So the real bad idea is being really wordy, like I'm being right now, with your meeting minutes. They get maintained in a written form or other form that can be converted to a written form within a reasonable time. A voter abstention is recorded. One thing that I get questions about is if the association records a meeting, is that an official record of the association? And the answer is generally yes, but only until those meeting minutes are created from that recording. Once the meeting minutes are created and preferably adopted, that recording is no longer an official record of the association, according to Florida law. Material alterations are generally not something you'll have to worry about unless your governing documents say that you need a member vote in order to do them. It's basically making a change to the physical appearance of something in your community. The HOA Act, Chapter 720, Chapter 617, neither of them say you need a member vote before you can do this. But what they may say, and what you'll want to run by your counsel, is the association can't spend X amount of dollars for capital improvements without a member vote. Okay, that's what I see frequently. And occasionally you'll also have you can have no material alterations without a member vote. There are exceptions to this. For example, if you're doing something that is more protective for the association than what you had before, you generally won't need a member meeting, even though the declaration says you do. But that's something, again, you're going to want to run by your attorney each time you're considering one of these alterations. Rules and regulations we talked about. Keep in mind, again, if we're talking about rules regulating parcel use, lot use, that is a 14-day notice. If it's regarding policies, one of the 4 we've talked about so far, or if it's architectural criteria, is generally going to be parcel use. But if it's regarding use of the clubhouse, rules of how the board is supposed to operate, things of that nature, that's only a 48-hour notice of a regular board meeting. Okay, Marketable Record Title Act is something you are legally obligated to think about and mention at a board meeting, the first one that's held after the election of your officers every year. Okay, so what is this? It basically says that if you've got covenants that govern your community, that's your use restrictions and things of that nature, your obligation to pay assessments, things like that. Those start to expire on a lot by lot basis unless you record something preserving them 30 years after the first sale to each unit owner, each lot owner. Now, the easier way to look at this, and the way that most attorneys think it actually works, is that you look at when their declaration was recorded and you preserve all of these instruments before that 30 years expires. The reason for that is that we know that there were no lots sold from the developer to any other member until after that declaration was recorded. So by going by the date of recording the declaration, you don't have to do a lot by lot analysis to determine what that date is, and you can protect the association quicker, smoother, and safer. I won't go into this in detail, but basically, if your covenants expire because you failed to do this within those 30 years, just understand you still have declaration, you still have covenants that the association needs to follow, but the members would not be obligated to follow any of the covenants anymore. What that means is you've got obligations and no means to fund them other than by voluntary payment of assessments by your members. So make sure, this is very crucial to make sure that these covenants don't expire. And what that means is having your attorney, when they pull those governing documents, which should be the first thing that you do when you have a new attorney working with you, when they pull those governing documents, they should be making a determination of what that 30-year date would be. If you've already preserved, it should be 30 years from the date of that preservation instrument. Now, one thing that I see come up frequently is in October of 2018, there was a law that was put in place that said amendments that refer back to the recording information of the declaration will act to preserve those covenants. So you're going to want to name all of the amendments to the declaration as well that added covenants. What people seem to be misunderstanding is that if your covenants expired before that went into place, or an amendment was recorded before October 1st, 2018, that option didn't exist. And those covenants don't just jump back into existence because something was recorded and a statute changed afterwards. So these are really technical details that you'll want to discuss with your attorney. I'm not going to waste a ton of time on it, but it is very, very, very important that you comply with this Marketable Record Title Act. Moving on, you have to allow process servers to enter into your community. They may need to provide proof that they are a process server and have something to serve, but you do need to let them in. You can't keep them out. Process server is basically someone that's coming with legal documents to hand them to someone to be served with notices. Management. So there are certain requirements if you are sort of self-managed. The legislature is now clear that anything done for payment when the association contains 10 units or more, or has 10 units or more, or has an annual budget that exceeds $100,000. If that manager is doing any of these things in the first bullet, they need to be licensed. That doesn't mean that every community needs to hire a licensed manager. What it means is if you're going to use someone who is employed by the association and the association is paying and they're doing these tasks, it must be a licensed manager that does that task. That's why a lot of times, if you're going to hire, even if you're going to hire someone in-house that's working on the premises, you're going to want either a portfolio manager who is licensed and does the work, or someone that is on the premises that does the work, that is hired by a management company and is licensed, because it just makes life easier. You also get the scaling that you get at a management company that you wouldn't get with an individual manager that's just using your software. There are specific practices. There are limitations on how much indemnification the association can actually provide to the management company. That's really going to come into place when you think management did something wrong. Okay, we won't go into detail about that, but it's in detail a little bit more in the slides. Just understand the indemnification is generally going to be for regular negligence, and that's about all you can do. Emergency powers, we won't go into detail about, but understand the Florida legislature thought it was important, and I agree, that during a state of emergency, the association should have the ability to do certain things that it wouldn't be allowed to do if there were no emergency. But the thing to keep in mind is this, and a lot of people misunderstand this part too. It's not just that there's a state of emergency that's been declared for your particular area or statewide or nationwide. It's that that state of emergency is related to the problem that you're having, and that's going to cause, or you expect to cause, or already has caused damage or injury to persons or property. So for example, the entire state was in a state of emergency last week or the week before, whenever Milton came through, but it wasn't expected to really impact areas down in South Florida, for example. There would be some wind, some rain, but there wasn't a true emergency down in South Florida. So there wasn't any reasonable expectation that there would be damage or injury caused by or anticipated in connection with that state of emergency. These statutes would not have kicked in my opinion, for most of South Florida. The West South Florida, yes, probably. But Southeast Florida, Fort Lauderdale, Miami, Boca Raton, West Palm, chances are those areas would not have been impacted by it. So a lot of these emergency powers might not have actually kicked in. Okay, but make sure that if you have an emergency coming up, you have these slides readily available so you know what your ability to do to protect your community and its members will be and won't be, because it doesn't mean you can just do whatever the heck you want. What this emergency powers statute allows you to do is protect your community and protect your members from the emergency itself. Okay, so now that I've spent some time on that, it's unlawful for private entities to swipe a driver's license unless the person whose license is being swiped consents to it. Okay, and these exceptions do not apply to the association unless you're talking about goods or services with a method other than cash. Usually that's going to be a country club setting or something of that nature. But you cannot swipe, or more accurately, you cannot force someone to allow your security personnel to swipe their driver's license. What you can do is take a photograph of the driver's license, write down the information from the driver's license, photocopy or scan the driver's license, just not the little strip that's on the back. Okay, so you can store that information, you just can't swipe unless the person says it's okay. My perspective is there's probably no reason to even have the swiping machine at the community, just have a little handheld scanner. Debit cards, bottom line, use a credit card instead of a debit card if that's what you've been doing, because the legislature seems to think that unless you've gotten an expense approved in advance that pertains to the association and there is a written set of minutes or a written resolution in place, that you should be subject to criminal penalties just for using a debit card to buy supplies for the association. I think that's ridiculous, but I don't even understand the distinction between a debit card and a credit card or a check, but apparently the legislature sees a difference. So bottom line, I would recommend against using a debit card for any association purchases. But now keep in mind also, this only pertains to a debit card in the name of the association. But even if you're using it for what is in reality an appropriate expense, it's directly related to the association business. If you don't have that approved in writing in advance by the board, not just the president wrote me and said it was okay, but the entire board has voted on it somehow, either via resolution or via meeting minutes that have been adopted, that expenditure was illegal and a crime. I think it's ridiculous. It's the law. Can't commingle deposits that are received in connection with any rental or construction being done on the property with any other funds of the association. What does this mean? You have separate accounts for operating and these deposits. You need to track how these funds are moving around within the deposit account. Upon completion of the project, the deposit must be returned to the member within 30 days after receiving notice that it's done. Now, this could be a different reason. It could be a tenancy and the tenant moves out and the lease is over. What I would also recommend that isn't in the slides is make sure that you've got something in the form that's being completed when you are collecting this security deposit that specifies that the member, and not the construction company, not the tenant, not anybody else, the member gets that money back when this project is completed, and they have an obligation to tell you that the project is completed rather than you having to try and figure it out. And what that does is avoid the risk that I've seen other communities have, and I've had to file lawsuits that cost the association 10 grand for us to file and get out of and try and get the money back. It's called an interpleader. And that's when you've got the situation that I'm talking about is tenant says that money belongs to me, owner says that money belongs to me, association can't give it back to either one without risking being sued. And so the association says, I don't know what the heck you guys want me to do. I'm going to file a lawsuit and let the judge make a determination of who gets this money. And then the judge will make that determination. You'll have already extricated yourself from the situation, but you'll have spent 5-10 grand in attorney's fees. And in reality, most of these deposits are what, 3,000? So you've already spent more than you might even get back from asking for that money back from the court after depositing it in the court registry. So just be safe. Make sure that you've got something that says the member gets this money back in the form itself. Moving on, if a member makes a request for an accounting of where you're storing their funds and what you're doing with it, the association needs to provide that accounting to the member within 7 days after receiving that request. Litigation authority. The association can file whatever lawsuits it wants. The only limitation that's placed on it is going to be in your governing documents, which I can't speak to because I don't have them in front of me, or the statute says that if the amount is in controversy is in excess of $100,000, technically you need to obtain the affirmative vote of a majority of the members. I see this being used completely incorrectly on a fairly frequent basis and interpreted incorrectly. This doesn't mean if you think you're going to spend $100,000 in attorney's fees, you need a member vote. I have a situation right now that a client is dealing with where an owner keeps saying, no, you had to get a member vote. No, they didn't. Okay. there was not a specific damages figure included in the lawsuit. It was maybe less than 100,000. There was nothing that said we're seeking 100,000 in damages. And as a result, this statute doesn't apply. If it did apply, it's intended as a shield for the association, not a sword to be used by some random contractor down the street who says, well, you can't sue me, you didn't get the member vote. Okay. Sometimes we see this coming up with developers who have construction defects in place. Bottom line, they're misinterpreting this. So if someone brings it up, run that by your attorney and get an interpretation, because chances are, if this ever comes up, it's being used improperly. I think twice or three times in my entire career seen where this was actually an issue. Okay, architectural control. Most important thing that you need to know about architectural control is that the authority to deny any application to change the way a property looks needs to be placed in the declaration, okay, or architectural standards that are supported by the declaration. It needs to be specifically stated or reasonably inferred as to location, size, type, or appearance. Okay, those architectural guidelines are something that you should be putting out, but you should be running them by your attorney to make sure that if you don't want to allow fences in your community, your declaration says that you can restrict fences or at least limit the way that they should be built. If it's not in there, chances are you don't have the right to say you can't have a fence. If it doesn't say you can control the size of a fence, you can't put an architectural restriction in that says fences can be no taller than 6 feet or something of that nature. So just be careful. Make sure that you run these by your attorney before you try and adopt them so that you're not putting things in place that you can't actually use. You can't say no to an owner that asks to do something that's already directly stated in those in the declaration. So or in those architectural criteria. So if your criteria say you need to choose between a wire fence and a PVC fence or whatever the material is, if your architectural criteria say these are the only two options and someone chooses one of those options, you can't say no, it needs to be made of wood. That doesn't work. You need to amend the criteria before you're allowed to deny on that basis. There are limitations. We'll get into those later as to what you can and can't restrict now and whether that applies or not, which we discussed a little bit earlier. But the thing that does apply across the board is that if you're going to deny an application for an architectural modification, you need to specify the rule or covenant that the association relied on in denying the request and the specific aspect of the request that violated that rule or covenant. So what that means is we get to decide based on purely aesthetic grounds. That's not going to cut it anymore, guys. Sorry. Let's see. Yeah, I think we can skip some of this. Can't limit or place requirements on the interior of a structure that's not visible from the frontage or an adjacent parcel, an adjacent common area, or a golf course of the community. So you can't tell people you can't have an AC, refrigeration, heating, or ventilation system if it's not visible from these areas and is substantially similar to a system approved or recommended by the association. So in other words, you went with a different model isn't good enough to say you can't have this system if it's not visible from these locations. This came up last year and actually years before as to what you can and can't restrict. And this goes into our covenant enforcement class, so I won't go into detail about it, but flags, same thing, covenant enforcement. Hurricane protection is number 5, I guess, of the policies that I think every community should have. And the legislature says every community must have this one. It's essentially a hurricane protection specification for each structure on a parcel governed by the association. What does that mean? What are we going to allow and disallow? Are we going to allow shutters? Are we going to allow wood? Are we going to allow hurricane-proof glass, etc.? What colors are we going to require? All of this needs to be specified. Otherwise, the association cannot restrict any form of hurricane protection. And this is kind of makes sense. This is one of the few limitations on associations that I actually agree with, especially since it's as simple as putting in place these criteria as either part of your criteria or a separate policy and rule that governs the association. Now, keep in mind, this is supposed to be already in place. Keep in mind also, this is one of the trickier things where you do need a 14-day notice, because even though it is a general rule, it governs use of the parcels, the lots. So this is a 14-day notice. Get it done now. If you don't have one, if your attorney has not suggested this to you, they are not paying attention to the law, and you might want to run that by them. I'd be happy to consult with anyone who is in that situation. Moving forward, vehicle restrictions. I talked about the trucks. I talked about the work vehicles. So I won't go into detail about that. Contractor restrictions. The association documents cannot prohibit. I think this is absolutely absurd, but here we go, legislation. An owner cannot prohibit an owner from inviting, hiring, or allowing entry to a contractor or worker on the owner's parcel just because they're not on a preferred vendor list, or here's the kicker, because they don't have a professional or occupational license. The association can't require that person to present or prove possession of a professional or occupational license to be allowed to go do work within the community. I don't get it. So you're telling me that the association's required to allow unlicensed people to potentially not only destroy this home, but damage others. Sounds like a great idea. Good job, legislature. Budgets and reserves. The thing you need to know about budgets is that you do not need to follow them to the penny. I will repeat that because I want the people in the back to hear. You do not need to follow your budget to the penny. If you are backing into your budget, you're probably not doing everything that your association needs to properly be operated and maintained. Your budget is your best guess for next year of what you really believe reasonably you're going to spend. If you don't know what that is, a good bet is to take what last year's budget was, find out whether there are going to be any changes in your vendor's costs this year. So for example, look through your contracts, see if there's an automatic escalation clause in that contract. And if not, adjust for inflation at a minimum. Okay. So when people get upset that your assessment this year is going to be astronomically higher than what it was last year, that's what it should be. The members get to vote and say, no, we don't want that increase. We want you to say, no, we're not going to increase it. Well, that's what the members want you to do, but your fiduciary responsibility requires that the association make sure that its proposed budget that gets at least presented to the members and voted upon by the board is going to comply with your actual requirements this year. If you need amendments to clean up the community, if you need legal work to clean up the community, if your landscaping budget is way below and you've got a bunch of dead trees all over the place that need to be taken care of, you need to increase your budget, even if it makes you look bad to the members because the assessments increase. That is your legal obligation. It's up to them to promote and propose an alternative budget that allows for a dollar figure that's lower. You comply with your fiduciary duty, let them screw it up. Again, use last year's budget based on the actual expenses to plan for this year, plus the contract increases. Dollars that are in operating are not restricted to a particular purpose. That's another thing that people misunderstand. Your operating budget is not reserves. Your operating budget can be used for literally any purpose. Use it for whatever purpose you want, as long as it's an item that was in the budget. Let's see, operating expenses. I won't go through in detail. It's basically money that you're spending that's not reserves. And in an HOA, there's only a few ways to create reserves. One, it's in the governing documents already. Two, the members actually voted on it and it's in the meeting minutes somewhere. And three, the developer established the reserve. If you want to terminate a reserve that's not in the declaration, if it's in the deck, you need an amendment to the declaration. If it's not in there and it was created by the developer or the board, same deal. Majority of the members say, we don't want this. There's no more reserve. Okay, we're going to skip some of these terms because realistically, you probably don't need them. The one important thing in calculating them is you're taking whatever it's going to cost to fix this thing, repair or replace it, and divide by the number of years you've got left. So if I'm talking about a $100,000 roof, then we're going to put away, if it's going to last 10 years, we're putting away 10 grand a year. Okay, so we've got 10,000 for 10 years equals the 100,000 that it'll cost when this is expected to fail. That component is expected to die. Okay, that's the way that you calculate what you're putting aside. Now, you've got two different methods of reserves. One is the straight line method. You take each reserve asset and you do that calculation and you keep all that money together. So you've got, 10 grand for the roof, 3 grand for painting, 5 grand for resurfacing, and all that goes into the budget this year. The alternative is the pooled method, where you have all those 3 items, but you shove them together and you basically say, well, the first thing that's going to fail is the surfacing. The painting should last a while. The roof, we've got at least 10 to 15 years left, according to our last reserve study on the roof. So we're going to put away enough where we'll have the 3 grand that it's going to cost, or the 5 grand, I think I said, to resurface all of the roads in the community within whatever time it's going to take. Okay, you're just putting away the next component that's expected to fail and leaving the rest out, so to speak. Now you can waive, reduce, or terminate reserves. I talked about terminating. That's a majority of the total voting interest. If you want to waive or partially fund a reserve in an HOA specifically, it's different for condos, different for co-ops, but in an HOA, all you need is a majority of those voting in present or by proxy at a duly called member meeting. Okay, so that's a majority of the people that show up. That's to waive or partially fund. To get rid of it altogether and never fund it again unless the members decide they want to, that is a majority of the entire community. So understand the difference between a majority of the members versus a majority of the members voting in person or by proxy during a meeting. The latter one is just going to be whoever shows up, a majority of those people, presuming a quorum is met, need to vote in favor of this thing. If it's a majority of the members, if you've got a 100-lot community, you need 51 votes as long as none of those votes were suspended. Okay. Notice and adoption of the budget is an important one. Again, I talked about the 14 days that we think you should be providing. Another notice requirement will be to put the proposed budget and budget as adopted on your website if you're required to have one. If the budget is to be approved by the board, which it normally is, notice of the meeting is considered and adopted, must be conspicuously posted at least 48 hours before the meeting. I suggest you give 14 days notice just to be safe, but some people will say that's not required. You should be providing either a copy of the budget or notice that a copy is available in advance of the meeting. So you're providing that to the members. I suggest you send it to everyone so that you don't have to send the one after and send another notice. After the budget adoption, you must provide each member with a copy or a written notice that it's available. If it's requested, a copy must be provided. That is not part of a records inspection that the members have to pay for. Now, you should be providing it electronically if that's feasible, so it shouldn't really cost you anything other than time. And again, that is 10 business days after the receipt of the written request, like a records inspection request, but at no charge to the member. Assessments and foreclosures is another thing that we have a class on. I'm not going to go through it in detail other than to say we're talking about assessments, we're talking about collection and mortgage foreclosure and bankruptcy. So all of these topics are covered in the class that we have online. It's been recorded already. You're welcome to watch it. I'll go through a couple things here and there with respect to assessments, but bottom line, this is another one of those policies. I think it was the first one that I mentioned. I think everyone needs to have. So that's 5 policies so far. Disability related requests is number 6. That's going to be a little bit more detailed, but we'll get through the other ones in a minute. So special assessments, we talked about providing an accounting. This is one that I will talk about. If someone requests an accounting of what they owe the association that is a member of the community, you need to provide that information within 15 business days after receipt of the written request. If the debt is a fine and you don't provide that in time, they do not owe the fine anymore, even if you went through the ridiculous process to levy that fine. So just understand, if someone owes fines, this doesn't apply to assessments. The statute is clear that the fine is eliminated, not assessments, not key charges, fines. So if you hear someone saying, well, the statute just went into place and it says that if you didn't provide this within 15 business days, I don't owe you anything. No, that's not what it says unless they're paid up on everything else. It says that fines are eliminated. All right. Moving forward. Oh, the other thing here is that the owner can't submit a second request like this within 90 calendar days after you have provided this information. If you're changing the invoice delivery method, meaning you used to go with coupon books, now you're going to go ahead and send out a bunch of just invoices to each owner, completely separate and apart via email. That owner is entitled to notice of the change and is entitled to say, I'm going to stay silent and you have to keep sending me coupon books. I think it's a ridiculous thing for the legislature to say that they can do it that way. That the owner can basically avoid this obligation somehow, but that's what the legislature does, no matter how many times we point out that it doesn't really function properly. So just understand, you might want to talk to your attorney about whether you need to be sending notices multiple different ways for multiple different lots within your community. We talked about collection. We didn't go through interest and late fees. Late fees are not an automatic. Make sure that your governing documents provide for late fees before you start charging them. That's going to be the declaration of the bylaws. If it's not in there, you might consider, if you're doing other amendments, adding this one on so that the association ends up with basically free money is really what it is. It's a soft cost if you're going to waive it. The interest is automatic. So that's statutory, you're entitled to it. Same thing with attorneys' fees and costs, automatically entitled to it, presuming you follow the proper procedure to collect the assessments. The interest rate is going to be 18% unless the declaration states a different percentage. That 18% is the cap. So if your governing documents say interest accrues at 50% on all unpaid assessments, no, you're limited to 18. If it says that interest accrues at 10% on all unpaid assessments, it's 10%. If it's silent, you got 18. Or if it says the highest rate allowable by law, it's 18. And also, there's no interest on late fees, no interest on interest, no interest on attorney's fees and costs. There's interest on the assessment itself. Now, the thing to note is that even though I just said that, the way that the payments are applied leave the assessments due, even though people are making payments, until everything is paid in full. Because the payments that are received by the association, not sent to the association, but received, get applied first to interest, then late fees, then attorney's fees and costs, then to the assessment. So keep in mind, just because someone sends a payment and says this is payment in full, here we say restrictive endorsements are inapplicable. They don't work under Florida law. You can't say I sent my payment and it says paid in full when they owed 20 grand and they paid 5. Sorry, but you accept the payment. You apply it in the way that the Florida statutes require you to apply it so that you're not waiving that portion of the debt, which is what would happen if you rejected a payment, and you move on. You continue with your collection process. So the notice of late assessment is something your manager should be sending out. We prepare a form for all our clients unless they're working with a manager that already has a good form. I'm not going to go into detail about these pre-suit notices or mortgage foreclosure issues. Again, we're already at 1 o'clock and I want to get to some Q&A before we shut down, and we have a lot of slides to get through. So I would recommend you go ahead and check out our collection class, and we'll move on to financial reports after I take a quick sip.
Yeah, and what I'll do is I'll put the link for where the webinars and videos are in the chat.
Please
And keep
do.
in mind, when you watch any of these classes on demand on the website, just keep in mind, folks, that if you're a manager, there is no CEU. It's just for informational purposes only when you watch them on demand. And lastly, Alan, take one more sip. Just this question has come up quite a bit. Some of you are board members that are asking me via the Q&A or the chat, does this class count for continuing education? The answer is no. This is new board member certification for board members of an HOA, not the continuing education class. Okay, even if you've been on the board continuously, you will still have to take this as a board cert within the next year. Okay, but as far as as Alan mentioned earlier, but as far as continuing education goes, no provider in the state, including K. Bender Rembaum, we have not yet been informed about whether the classes we currently have, other than certifications, will count for new board member certification CEUs. Once we have that clarification and we begin to advertise our classes again for board members, we will let you know whether it counts for board member continuing education, not to be confused with certification. Hope that made sense. Alan, back to you.
All right, thank you. Good clarifications as well. Thanks, Jeff. So financial reports are the next subject. Financial reporting, even if you're a not-for-profit corporation, you do have to provide financial reports within 90 days after the end of the fiscal year or annually on the date provided in the bylaws. You have to provide that, not only have it prepared and completed, but provide it to the members. You need to provide it within 21 days after the financial report's completed or received from a third party. If you're using a third party, you get another 30 days so that that person can take a look at your records. And that could take a significant amount of time, especially if you're using someone that needs to provide an audit, which could be reviewing every single document of the association since the last audit, literally all of the official records. Obviously, that can take a significant amount of time. So you get a whole whopping month of additional time if you're producing this information to your accountant, your CPA, whoever it may be. My suggestion is as soon as that fiscal year is over and the manager is able to finish out their internal reports, get that information over, pardon me, so that you're providing as much time as humanly possible to that CPA to do the review. The level of financial reporting is different based on your size and based on your dollars. So if you have less than $150,000 in revenues, you just prepare a report of cash receipts and expenditures. This is your typical quick spreadsheet. Here's what we brought in. Here's what we paid out. Here's who it was from or to, and here's the date, and here's a general description of what it was. That's your entire financial reporting obligation because you're not bringing in enough that the legislature thinks it's crucial to do this full review. 150,000 or more, but less than 300 grand. And we do call this the mo money, mo problems paradigm. It's just a compiled financial statement. What that means is there's a little bit of review going on. You're providing your records to the accountant, and they're taking a look at your financial records for the most part. Doesn't require a CPA. And then you've got 300,000 but less than 500,000 is a reviewed statement. Little bit more review, little bit more scrutiny of the records. And then finally, you've got the big mamma jamma, the 500,000 or more is a full-on audit. Now, the difference that came about this year, and it's up in the second bullet here, if you have at least 1,000 lots in your community, you also need to prepare an audited financial statement, regardless of how many dollars you're bringing in. So even if your assessment is a penny per lot, you still will need this, even though you're less than 150 grand in revenues for the year, if you have 1,000 parcels or more. Again, that is an audit for either 500,000 or more in revenue, or at least 100,000 parcels. Keep in mind, when I say revenue, I don't mean profit. You shouldn't have a profit. It means that you brought the money in, even though you might have had 800,000 in expenses. You can vote by 20% of the owners to raise the reporting level. That is a majority of the total voting interests. So you would be increasing your review. You can also decrease by a majority of a quorum. Okay. We talked about the timeline already. You need to amend the budget or adopt a special assessment to pay for this financial report if it's not in the governing documents, or I'm sorry, if it's not in the budget already. You don't have a choice to say we didn't have the money, so we didn't do our annual reporting. Does not work that way. Okay, so I remembered this. I mentioned it. The other thing that needs to be mentioned is those financial reports. If the association is preparing them, you need to be aware of this. If not, it should be the person that's preparing them that's aware. Basically, if you are not reserving for assets and putting money away for problems that might arise in the future, for example, clubhouse renovations, whatever it may be, your roofs that need to be repaired, whatever it is, you need to put these statements into the budget and basically say, well, I might need a huge special assessment if one of these assets fails. So instead of the reserves, you're basically saying, we're not putting money away, so you might need to pay it out in the future instead. Contracts and bids. Now, keep in mind while you're listening to this, everything that we previously mentioned with respect to conflicts of interest. Okay, contracts need to be in writing, and this is the Florida statute of frauds. If the contract can't be fully performed within 1 year and it's for the purchase or lease of materials or equipment, or it's a service contract. Okay, so these things need to be in writing. Your contract should not be someone's estimate that you signed. I see that so frequently with our current clients that it drives me out of my mind. There is zero protection for the association if this contractor screws up and you don't have a real contract that your attorney put together for you. Okay, so anytime you're going to sign something, even if it's $100, I don't care. Factor the expense of your attorney creating a real contract for you into the expense of the contract. Because if you don't do that and someone causes 10 grand worth of damage, you're on the hook for that 10 grand. If they cause 150,000 worth of damage, you're probably on the hook for that 150 grand. Would you rather spend, I'd say, a maximum of $2,000 to $3,000 for a very basic contract, or would you just take the risk? If you just take the risk, you probably haven't been paying attention during this class. Okay. The contract should include, and it's not going to be included if you're dealing with just a standard estimate that gets signed off. The obligations of the party contracting to provide maintenance or management services. That is generally going to be very vague and list part numbers and things like that if all you're getting is an estimate. You want it to be a very clear scope of operation of what these people are going to do. What's the cost to be incurred for each of the services? What does it actually include? Okay, if they say all of a sudden, well, this was our estimate, but we're not bound by that, then you didn't have a contract. Okay, if they say this is our estimate, but we needed to do X, Y, and Z because we didn't investigate first, then you should have had your attorney protect you with a contract to say, I've investigated on the contractor's end. We've investigated and we think that this is all that's going to be required. And if it requires more, you are allowed to sign off on a change order. Okay. The frequency that the service will be performed. Do you have time is of the essence clauses? Is there a timeline for them to do the work, or do they get a reasonable time, which could be 6 months when you were expecting 6 weeks? What is the minimum number of personnel? Do the personnel need to speak English? Do they need to have insurance? Do they need to have any kind of workers' comp so that if someone gets hurt on the premises, you don't get sued? Okay. Are there attorney's fee provisions so that if you have to sue them to get them to complete the work or pay you the difference, you're not just stuck spending dollars that you will never get back because you have no attorney's fee provision? I have a lot of communities that have unfortunately said, I'll sign the estimate. The contractor screwed up and they asked me, well, should we sue them? Well, it's a $5,000 fix and it'd cost you at least that just to get through filing the lawsuit and service a process if we were to go and pursue it. Now it was specific. It might be less money than that, but there's no way you're getting through a full-on lawsuit regarding a breach of contract that isn't a standard collection or covenant enforcement matter with $5 grand. So make sure that you've got the provisions you need. Have your attorney prepare all of your contracts, or at minimum, have them review and point out the risks that you're deciding to take instead of having the attorney prepare something before you sign. And if you've got a president who just signs contract that weren't run by the board, that person should be removed as president immediately. Let's see. Bidding. You do not have to get bids for certain professionals. You do need to get bids if the aggregate cost is more than 10% of the annual total budget, including reserves, which it rarely will be. The lowest bid does not need to be accepted. You have to accept the best bid for the association. The association doesn't need to get bids if there's no one else in the area that does the work, or if there is an emergency and that is what is causing the work to be done. Contracts that were executed before October 1st of 2004, so 20 years old now, and any renewals of those contracts, which is why we're still mentioning them, are not subject to the competitive bid requirements that we're talking about. Same thing with employees of the association, attorneys, accountants, architects, CAMs. If by competitive bid, those contracts can be made for up to 3 years. Engineers and landscape architects. All those contracts must be in writing, but you do not need to get bids for these people that are listed here. If the contract is awarded under competitive bidding procedures, any renewal that contains a provision that allows the association to cancel the contract on 30 days notice is okay. An association where the governing documents provide for competitive bidding may operate under the provisions of those documents in lieu of the state statute, as long as they are not less strict than the statutory requirements. Short story, if your governing documents require more, meaning if it's 5% instead of the 10% I just mentioned, that will require you to do competitive bidding, okay, you follow your governing documents. Now, keep in mind, that's a may, not a must. So follow whatever's easiest. Communication services. I think we have a whole class on bulk communication contracts. This is your typical Hotwire, Comcast, those types of companies. There are specific specialty items in the statute that pertain to canceling those contracts by the members, but we're going to skip them for now because, like I said, we've got a whole class. Transfer fees and estoppel certificates are generally covered in the assessment portion of the assessment webinar itself, but I do want to mention that transfer fees pertaining to, hey, you bought the property, you're selling the property, there's a capital contribution. They are allowed. If you have a limitation, let's say it's 1 month of assessments and you don't think that's good enough, what I suggest is consider amending so that the board gets to decide on the dollar figure from time to time by written resolution. Instead of it being $1,000 now or $300 now, and then 5 years from now that number's not enough and you amend, and then 5 years later you decide and you have decided on a number that is now also not enough. So you're amending and amending and amending. Make it so that the board gets to decide what that dollar figure is from time to time. It'll make your life a lot easier, and it'll make the future boards' lives a lot easier. The one thing I will say about estoppel certificates, make sure if you get a request for this, it goes to your manager and your attorney if the account's with the attorney immediately, because anything that's not in here is not going to be recovered after this transaction happens. An estoppel certificate is basically a document that people request when they're trying to refinance, get a new mortgage, or they're trying to close on a sale of the property. And they're trying to make sure they do that without any kind of obligations owed to the association beyond what every member owes the association after the closing takes place. So it's basically a document that says, here's what it'll take for you to be able to start from square one after this closing's complete. You want to make sure that if you have an account that's with your attorney, that you get with the attorney, because if you don't include those attorney's fees and costs, for example, we have a program that's optional. It's a special program that says you only pay the attorney's fees and costs incurred in collection after the file gets closed out, and only if we don't collect. So what that means is that we haven't told you for the year or two that this file's been in collection what the attorney's fees and costs are, because we didn't charge you. Now that information is available on our website for our clients, but, and when I say on our website, I mean individual clients have an individual portal to check into. But what that means is that you have no idea, you're not putting that information in there. And if we've spent 5-10 grand in attorney's fees and never charged you any of it, all of a sudden those attorney's fees and costs become uncollectible if the closing occurs based on this estoppel certificate that didn't include them. So those are the most important things I think you need to know about this. Here's just the content of what goes into the estoppel certificate, what the expenses are that the association can charge. You can only charge these fees if you've got a written resolution of the board that says you can charge them, or it's directly in the management contract. So make sure you've got one of those two so that you can get the benefit of taking the time and preparing these estoppel certificates, getting that dollar figure back as a cost of doing business and a cost of creating that expense. If you don't deliver this on time, you cannot charge anything for it. And that is within 10 business days after you receive the request, which is why I say get that to your manager, get that to your attorney ASAP to make sure that they have the time to complete the request. The other thing I mentioned is if they're sent via email or fax, 30. The person that paid the money asks to get it back, you actually have to send the money back to them. You just add that expense onto the account as an assessment. But just understand, a lot of people don't realize, because frankly, a lot of title agents don't bother to ask for the money back. When you do get that request, don't ignore it, because that person's entitled to the money. Let's see. We talked about the effective period. If there is a change in circumstances, there's another violation that arises, someone pays part of the assessment. If that happens during the validity of the estoppel certificate, make sure that you issue an amended certificate so that the information is correct at the time that they close. You can't charge for that amended certificate, and it's good for another 30 days, but you should be issuing one if the estoppel certificate is no longer accurate. Okay, covenant enforcement, we've got a class on, we've talked about some of it, but the most important thing is this is policy number either 6 or 7 that I think every community should have. If the violation comes up, what are we going to do about it and when? Now, all of these policies, at least the way I draft them, automate these processes. It's management has the authority to do what they're supposed to be doing. Then they have the authority without a board meeting to send it over to council, who then has the authority to do whatever they need to do with the file. The manager also has the authority to pay any cost deposit that the association needs to pay to their attorneys to keep the file moving forward. Okay, so this is one of those policies that I think everyone should have. What are we going to do if you don't keep your word? And by keep your word, I mean, what are we going to do if you violate one of the covenants, the rules, the architectural criteria of the association? The first step should be basically to send a letter saying, hey, you didn't do what you're supposed to do. And I think Sentry usually sends 3 notices before you go, pardon me, before you go to the attorney stage. That's fine. I don't have a problem with sending those 3 notices. Frankly, it's fairly standard. But if the association decides to only send 1 notice from management, that's fine. We'll get into self-help, which is physically going on to a lot and curing a violation. That's something that some communities will do before it reaches the attorney for things that they're authorized by the governing documents to do. So make sure that you have your attorney at least look at that, prepare forms for the association to use so that you don't have to refer all those matters to the attorney. You just take care of them and they're done. And if the owner impedes those self-help efforts, then it reaches the attorney. Because keep in mind, you're going to have to do that if you've got the right to do it before you can file a lawsuit trying to get an injunction. Now, there are fines discussed in these slides. I think fining is a waste of time. We do have a class on fining for HOAs that will be taught and offered as a 4-credit for directors and managers type of class in the near future. But fining, all it does is tell people you owe me some money, and that's either going to not cure the violation in the first place, which was the goal of the fines, and also it's going to result in people that have enough money to say, I'm going to spend 100 grand putting in a pool. They're not going to care that they have to pay you another $1,000 just to be done with the association. If that's all you're doing is fining members, you are not doing covenant enforcement, period, from my perspective. All right, so now we can blitz through some of this. Use right suspensions are another useful tool. They're going to require prior notice. You'll go through what that procedure is with your attorney, but it's basically you have a board meeting. If the use right suspension pertains to violations of rules and regulations and covenants and not monetary obligations, then you're going to have another 14-day notice, just like fining, before a committee that is not the directors, officers, managers, or their spouses. And that group is going to decide whether the suspension or the fine actually goes forward. If the violation's cured before that meeting, sorry, but you're out of luck, which is why I say fining is a waste of time, because if the owner can keep curing and keep avoiding the fines and you're not doing anything about it other than the fining, then all you're doing is wasting time sending multiple notices and paying the association manager to go through these processes without any real resolution other than, well, they cured it for 3 weeks, 6 weeks, 6 months, but we have that pop up right over again. All right, we're at 1:30. I'm glad that we're gonna skip through a couple of these things. Pre-suit mediation is basically a process where everyone goes into a room. We try and resolve this thing, and if we can't, then the party that was pursuing the claim gets to file their lawsuit and seek the injunction. The way that I do these, or at least our firm has started doing them based on my suggestion, when you send out your demand for pre-suit mediation, if you are using your attorney to deal with the self-help, have your attorney send out that demand notice to do the self-help at the same time. That way, when you go to mediation, if it doesn't settle the next day, you've already got your self-help scheduled. And it's either we settle today and the owner is amicable and we can get this done with a written settlement agreement, or we're going to come onto your property tomorrow and cure the violation anyway. And then you'll pay for the cost of curing the violation. The issue then becomes the attorney's fees and costs that were incurred in getting to that point. One of the amendments that I recommend everyone look into, if you don't already have this in your documents, which most communities don't, is an amendment that says all fees and costs incurred by the association in covenant enforcement are an assessment against the responsible lot. Now, that would basically be an assessment that kicks in either when the violation is cured, even if that's pre-suit, or once you get your judgment. That way you don't have to get a fee hearing and find out what you're entitled to, and you can collect it immediately as an assessment. Now, moving on. Pre-suit mediation, we talked about. Prevailing party fees, we talked about. You're generally not going to get your fees and costs back unless you have that amendment in place. If you're pursuing enforcement, they can be recovered as part of the settlement process, or they can be recovered by post-judgment collection. But that post-judgment collection costs money in and of itself, and those expenses are also not recoverable. So what you're doing is, I hate to be blunt, but you're throwing good money after bad in most instances, unless you think that person's got a bunch of money and they made you spend, $20,000 to get through that lawsuit. Then it might be worth it. But most communities are going to look at it and say, well, we only got charged $5,000-$6,000 to get through this lawsuit. We're not going to spend another 4 or 5 to try and recover 5 or 6. So that amendment that I mentioned a moment ago is the way to get around that mentality of saying, well, we're not going to do it if it's just the cost of doing business, to try and make sure that people are complying with the covenants. Talked about self-help, insurance, basically maintain adequate insurance. What is adequate for your community is dependent on your community, so I can't give you a lot of guidance. What I will say is have flood insurance, which is separate and apart from some other policies. Have directors and officers liability insurance, and have a separate policy. And directors and officers is basically, it protects alleged breaches of fiduciary duty, acts and omissions by the officers and directors, so that you're not just paying for their defense by paying a law firm like ours to defend litigation. You're paying the insurance deductible, and the insurance company will presumably appoint an attorney to defend those people. You also want to have insurance for damage to property, damage to people that happens on association property or within the community. You also will have fidelity coverage that covers people who control or disperse association funds. Covered perils, you need to know what's actually covered under your insurance policy. So you're going to want to run that by your agent and most likely your attorney as well. If something is not covered, you are not insured for it, period. There are statutes of limitations as to when you can submit an insurance claim. You'll want to do that immediately if you ever intend to do so. There's actually case law that came out fairly recently that says if you have coverage, but you're required to submit within a reasonable time, or almost, I don't remember the exact terminology in the case, but it essentially said that someone who waited 2 years and 6 months and their policy said it needed to be filed within 3 years had still waited too long to submit a claim for insurance coverage for hurricane damage, because it wasn't done immediately and the carrier couldn't make a clear and easy determination of whether that damage occurred during the one storm that they claimed, the association claimed it occurred during, or the 3 that had occurred subsequent to that storm. So bottom line, make sure that if you have an insurance claim, submit it as quickly as possible, get that coverage. And especially if you get sued, run that by your attorney as to, is this something we should be considering submitting for insurance coverage, so that we don't have to pay you attorneys to defend this entire claim at your regular hourly rates. Fair Housing Act is one we also have a class on. This is your disability policy kicking in. Basically, if someone has a disability and needs an emotional support animal, another support animal for other purposes other than emotion, or needs a service animal that does a designated task or tasks, You cannot prohibit them from having that animal in the property. It is not a pet, it is an animal. So if you've got a pet restriction, size restriction, number restriction, that will not apply to that particular animal or those particular animals. But again, we've got a class on it. It's already 134, and I'm going to move on. So I do suggest the materials here are helpful, but they're not everything that's included in that other class. So I would suggest you check that out. Recalls of directors. This is another thing you're going to want to get to your attorney literally within minutes after you receive a recall petition, because the board only has 5 business days to decide whether to certify the recall, meaning you're going to have a meeting, and during that meeting, you're going to decide, do we want to say this person who is being recalled, meaning they are being removed by vote of the members, are we going to remove them, or are we going to keep them in place? And the members are going to have to do something about that. Any director can be recalled and removed from office with or without cause. This is the important thing. It's not, well, you did these 50 things wrong, or even you did this one thing wrong. It's, we don't want you on the board anymore. Doesn't matter why. Now, that's done by a majority of the total voting interest in the community. Now, if you are recalled by meeting, that meeting can be asked for by 10% of the voting interest giving notice of the meeting. Okay. Now, that means that you're scheduling a meeting as a result of the 10% saying we want it. If you're recalling by written agreement, that's just a petition that a majority of the members have signed off. So think about if you've got a 1,600 lot community, which is one of the ones that I deal with on a regular basis, that's at least 801 votes that the attorney needs to review and decide whether they were legally sufficient. 801 ballots for this recall within 5 business days. And then the board holds the meeting within those 5 business days. So this is a huge undertaking. It's a big deal. And most of the time people screw it up. And that's why you want your attorney to look at it, because if you can say, well, you got 801 ballots, but 2 of them were invalid, sorry, you didn't get your vote. Even if one of them is invalid, you didn't get your vote. So I mentioned the 5 business days. The division of arbitration will generally rule on these recalls. They won't do that if you are within 60 days before or after a scheduled election. So just understand, you can't file an action in court. You can't file a petition for arbitration if there is an election scheduled that just took place and there's still time to file an election challenge, or there's an election coming up and the recall is going to be completely meaningless as a result. Filling vacancies created by a recall. If you've got a majority or more of the directors, the recall will generally state who you're going to replace those directors with, or that election takes place during the recall meeting. If it's less than a quorum, the vacancy can be filled by whoever else is left on the board, or they can decide to have an election, although they don't need to. Turnover is basically the transition from control by the developer to control by the actual end users, the members. That is going to happen at least 50% of the parcels in all phases being sold out. That's where you get your first member director. Moving on, you get your full turnover, and you get at least a majority of the board when the earlier of these things happens. Now, there might be other things that are in your governing documents that will trigger a turnover, but it's 3 months after 90% of the parcels in all phases have been sold. Another percentage has been conveyed to the members as set forth in the governing documents, or the developer has abandoned or deserted the responsibility to maintain and create the infrastructure. There is a rebuttable presumption that that happened if the developer has unpaid assessments or guaranteed amounts for more than 2 years. If the developer files for bankruptcy protection under Chapter 7, which is just restructuring, or I'm sorry, is basically avoiding personal responsibility for debt as a business in this instance. The developer loses title through foreclosure unless the successor owner accepted an assignment of developer rights and responsibilities, or a receiver for the association is appointed and is not terminated within 30 days after the appointment. Now, that receiver is generally going to be requested by one of the members of the community. The developer is entitled to elect at least one director as long as they have at least 5% of the parcels in all phases being held out for sale. Once they just hold that property and stop trying to sell it, that doesn't matter anymore. And that unit, that lot does not count toward the 5% anymore. After they relinquish control of the HOA, they can exercise the right to vote as the same as any other member, except for purposes of their reacquiring control of the HOA or selecting a majority of the members of the board. So they basically get the same rights as any other member, but they can't use that fact to jump back in and say, I'm going to take control again. After turnover within 90 days, there's a lot of documentation the developer is supposed to provide. One thing that I recommend for every community, get an engineer out to the community to inspect everything and make sure that you don't have any construction defects that the developer's engineer or architect or other contractor chose not to tell you about because the developer was selective in what they wanted that person to look at as part of this reporting upon turnover. But that's within 90 days after the members are elected to at least a majority of the board. And that is it. So I have 20 minutes left for Q&A, and you guys can head out after that. I will stick around slightly longer, but I do have another meeting shortly after we're supposed to be done here today. But I did want to make sure to get through at least most of the presentation. I do think that the collection, the fair housing, and the covenant enforcement webinars that we have are extremely helpful. And so I recommend that if those are issues that your community is facing, check those out. And frankly, before your community is facing them, check those out as well so that you have the knowledge like you're going to have with some of the things we went through today. I appreciate everyone showing up today. For those of you that do decide to take off, hopefully it won't be many, but we are through the material. Jeff, do they need to stick around until 3 or until 2 all of a sudden?
No, I was just going to mention somebody just asked in there. You do not need to stick around. We'd like you to, but you don't need to stick around for the Q&A. There's no mandate for the length of time of an HOA certification class. So the condominium class, that's the crazy 4 hours. This one is however long it takes, and Alan just got it done. While Alan's looking through some of the Q&A, I want to mention not every question will get answered. There are a lot of them. We have a little time left, and I also want to quickly go over right now. Edward, I'm about to go over that in the chat area. Okay. I just placed the link for the evaluation into the chat. And excuse me. And when you click on that link, it's going to it's going to open up a new browser tab on your browser. This is the evaluation. Okay. We need you to fill this out. This is the data that is used to populate the fields that create the certificate and then gets it emailed to you. If you are a Sentry client, question number 1B, are you a board member for a Sentry management managed HOA? You're going to choose yes or no. And that's so we know what to get to the folks, to the fine folks over at Sentry for filing it for you. You'll still get a certificate from us if you're a Sentry management client, but you don't need to do anything with it because Sentry will take care of it for you. If you are not a Sentry management client, and you've taken our courses before, it's the same thing. You fill out this evaluation, you hit submit. After you hit that submit button, you're going to get this confirmation screen. Notice here, it's going to happen a lot quicker than that, but things happen. I'm giving 10 to 12 business days at the worst. You'll have your certificates, probably a lot sooner, but just keep in mind, it's not instant like it used to be. It used to be right here on the screen. We can't do that anymore because of the new certificate we have to use given to us by the state. So anything referring to this class, if you have any questions, you could email me at seminars@kbrlegal.com to contact Alan. His email address will appear there as well. And then those of you asking about the slides, download and save the slides by clicking there. Then they'll open up and you can download and print them or save them. I'll go over this again after Alan addresses some of the Q&A. But again, this is what we need and the data that we use to create the information that goes onto your certificates. And again, that little leeway in time, that's what we need just to verify that you attended in full, because the division is a lot stricter than they used to be. They are checking to make sure that we have accurate records showing you attended for the entire class and not just a portion of it. Okay. So Alan, I'll go over that again a little bit later. Back to you, sir, for some of the Q&A.
All right. So I'm just going to go down the list, and once we get to the point where we need to cut it off, we'll do our usual thing, Jeff.
Yeah,
Uh,
about 15 minutes.
yeah. Okay. Nancy asks, when there's a master association the A is a member of, aren't they subject to all the same statutes as HOAs? Or can their requirements be different? If different, how can we find out what they're required to follow? Generally speaking, that community is going to be subject to the same um, obligations, presuming that master association is in and of itself an HOA. If they're not, then they'd be subject to other statutory requirements. Chances are, keep in mind also, they're probably going to be subject to different requirements than your sub-association as a master. So that those different requirements would be found in the individual governing documents of each of the two communities. So that's where you'd be looking at. Will I be providing something of detail that explains 617 and 720 in more detail? There's really not a whole lot more detail to provide it. I'm sorry, Michael, but essentially we're looking at 617 governs not-for-profits, 720 governs HOAs. If there's a conflict or you think there's a conflict, you need to run it by your attorney.
Alan, you've been speaking for 3 hours straight. Let me give you a bit of a break. I'll read the questions to give you a few second reprieve here.
Okay.
Um, Andrew says, I was asking, our architecture board said they are separate from and not beholden to the overall HOA. Does that seem true?
Probably not, but I have seen some communities where they are treated as a completely separate board. It's going to depend on how your governing documents are structured. So that's one that's going to need to go to your specific attorney.
Okay. Dylan asks, our bylaws dictate a service, cable inclusion in the assessment, that homeowners typically beg the board to do away with, but we can't get a quorum to enact the vote. Is there a way to get around quorum, which is something like 75 or 80%, when we cannot get the necessary number of homeowners to vote? Many of our investors are living abroad.
I have a feeling that it's not the quorum requirement that's 75 or 80%. It's actually the amendment requirement. And the only thing that the members would be able to do is push really hard one time for an amendment that will change that voting percentage. But beyond that, if your governing documents specify that cable is to be included, I don't know why that would be directly in your governing documents,
Yeah, it's
but
weird.
if that's what's in there, that's what's in there.
Okay.
Not much you can do other than go to the statute and see if there's a way to terminate under the statute. But if you're under a contract that's not relatively new, you're probably stuck with it.
And I would say double check what it actually says in there because I find, like Alan just mentioned, I find that kind of odd, being especially how quickly technology changes, every year. It's just kind of bizarre that that would be in there. So maybe clarify that that's actually what it says as well. Right,
Right.
Alan? Would that be good advice?
Yeah, I mean, I would have your attorney take a look at the provision. If the members in general want to get out of it, make sure that your board is actually supporting this from the inception,
Yeah,
presuming that you're on the board because you're here today. But have your board send that question over to the attorney. Is there any way to get out of this?
yeah. Jennifer asking to clarify, is it 14-day notice just for annual or special meeting?
So depends what you mean by just. If it is a
Compared to a regular board meeting, I think.
Yeah, I mean, if this is annual or special, we're actually referring to member meetings, and the answer is yes. You're going to provide 14 days notice for any of those in an HOA unless your governing documents say something weird. If you're talking about what board meetings might require that, if it's your regular assessments, I think that it should be 14 days, although some people will say 48 hours notice for the budget meeting. If it's a special assessment, definitely 14 days notice. If it's a change to parcel use, meaning rules and regulations governing the use of the lots, that will also require a 14-day notice.
And every time you say 48 hours, I think of Eddie Murphy and Nick Nolte. I can't help it. Dave is asking if there are multiple associations within one community, is each association required to have a website? For example, we have the master, then a townhomes association, and a state association, so on and so forth, all separately registered associations. Good question.
Yeah, good question. And unfortunately, the answer is yes, because there's nothing in the statute that specifies that you can have one joint website for the records pertaining to multiple different operations, multiple different corporations. The only solution there is the banana in the tailpipe.
Different Eddie Murphy movie, but a great analogy. That's Beverly Hills Cop.
Yep.
Okay, so regarding proxies, if a meeting has to be postponed due to weather but is rescheduled within 90 days, are the proxies still good? The previous
As,
ones.
as long as the meeting is taking place within 90 days from the original scheduled date, the proxies are still good, presuming they
Okay.
were good in the first place.
Presuming it was correct in the first place, right? Must you or can you provide a right to cure a ballot?
Don't know what that means.
I'm
Sorry.
not sure either. That was hence the puzzled look on my face. Okay.
The right to cure a ballot doesn't exist. Either the ballot was valid or it wasn't.
Okay. So if we
The
didn't
answer.
answer it properly, just clarify. And if we get to it, if we have enough time, we'll get to a follow-up at the end if we have enough time. Seems to be a conflict. Five director terms expire and four candidates for the election. Four candidates automatically in, but still need an election for the fifth.
Well, that's going to depend on how your community operates and what your bylaws say. If those four directors have their terms not expiring yet, then yes, they'll stay on and you'll have an election for the fifth. If all of them have a 1 year term, then technically all of them need to be elected unless there was not a fifth person that put their name in the proverbial hat, at which point you don't have an election for that person. You have the remaining four directors appoint the fifth person.
Okay. Can a president vote? Can a president who's also a director vote?
I think we specifically addressed this identical question. The president doesn't vote, the directors vote. So the president happening to be a director gets to vote as a director. They just don't get to vote as president.
As a
The
president.
president, vice president, secretary, treasurer, those are not voting positions. Those are positions with responsibilities. So that was the distinction I was making. The directors all get to vote, regardless of whether they're also members, regardless of whether they're also the president, the VP, whatever.
Okay, I hope that clarifies it for you. Thank you, Alan. Can you remove a board member if they do not timely comply with the new financial requirements and or board property manager request to collect the info so that I'm not sure
It's
what that
it's
means.
FinCEN, and what this person is asking is if the person does not comply with the Corporate Transparency Act,
Oh,
which is kicking in and requires certain information of the individual directors be filed with the federal government by December 31st of this year. Can you kick them off the board for not doing that? Unfortunately, the answer is that's not one of the things that the statute says you're allowed to kick someone off the board for, because it's absolutely absurd that we even have to comply with this when FinCEN is requiring this information, and the statute came about to protect for terrorist activity that is using funds of corporations. I'm not aware. I know that there's plenty of crimes going on pertaining to community associations. Terrorism is not one that I've heard of
yeah,
association being used for.
yeah. Well, I've been doing this forever, as you know, and that's a new acronym I learned, the FinCEN. Okay.
Then, yeah.
So, Brooke is asking, and this comes up, Alan, you're going to nod your head. This comes up all the time. If you have a small board, or actually, it doesn't matter what size your board is, and you're sharing responsibilities, are you able to have the board meet with a vendor to hear their info or to walk through their proposal? No decisions being made, only information gathering. So, and you did nod your head. We get this all the time.
And this is what I said earlier. Some will say that is a board meeting because you have a quorum of the board trying to conduct business. My opinion is, especially in that instance, the suggestion I had before was you've got 10 potential vendors and you're narrowing it down to three. Here, it's even clearer from my perspective, although, again, not everyone that is an attorney, including experts in this field, will agree. From my perspective, you are explicitly not making decisions, which means you are explicitly not conducting association business, which is the term that the statute uses. But again, you could have attorneys go either way on this. My recommendation is get a written opinion of counsel so that you have something to rely on when someone says you were supposed to do this during an open meeting. Your response is, we relied on advice of counsel. What do you want from me?
Okay. Dylan is asking, this is interesting because in many ways, this is a synonymous thing. We have a website plus a portal, okay? Because there are websites that have portals to get into the back end. So they're synonymous.
Right.
We don't currently have access to change the website. So will posting meetings to the portal suffice?
If you have to have a website, because keep in mind, if you have 99 lots in your community, you don't need one. I got 99 lots, but a website ain't one. The requirement would be that you actually create a new website that will provide you access to be able to post those notices on the front page. Regardless of whether you already have a portal or anything else, it's very clear in the statute that that information needs to be directly on the front page of the website.
Okay.
Sorry
And
to
if they,
tell you,
and they
Mike.
don't have to be fancy. It could be a plain old app. It could be, as long as
Right.
it's password and username protected. It doesn't have to be this fancy schmancy thing.
The other thing that I would suggest is presumably you're using someone for hosting. If you don't have access to your direct website on your own, contact whoever's hosting that website or whoever designed it and try and gain that access.
Great advice. Can somebody be on the board if he or she is in foreclosure?
Nope, 90 days, you're off. If someone has any delinquency for 90 days or more, they are automatically off the board. They are treated to have abandoned their post.
That answers the next question as well. We're going to skip that one because they were pretty much the same.
No, it
Uh,
wasn't the same from what I saw. It was property upkeep. There's a distinction between owing money and
oh,
not maintaining your property. So that failure to maintain the property generally will not get you off the board unless and until the association decides to levy fines for failure to properly maintain your lot. Those fines, if not paid, will have you removed from the board.
got you. Thank you for
Or
that.
if self-help performed and the assessment regarding the self-help is not paid within the 90 days, then you're off the board as well.
Then you're off the board. Thank you for that. I jumped the gun there. 5 minutes left. So let's do a few more here. Nancy's asking, can a director or officer have a lawn company? Hang on. So can a director or officer can have a lawn company that is owned by the director or officer? Is it a conflict?
So I presume you're referring to that lawn company doing business with the association and
I
going,
would assume so. Yeah.
doing business in the community is generally not a conflict. Doing business with the association itself is, but that doesn't mean you can't do it. As I mentioned several times while I was discussing conflicts, the association is allowed to have a conflict of interest. That doesn't mean you can't contract with the person, doesn't mean that it's the worst idea in the world and that it's going to end the association. All it means is that there are certain disclosure requirements that are going to apply before you can really sign that contract.
Okay. Next question is from Carol. And I want to just point out, Carol, you were emailing me on the side with some things that might be a good idea to clarify. I want to thank you for that because all of the input that about these new requirements that are out there can be confusing. And I want to thank you for pointing out what you pointed out. That will help make it easier for others to understand going forward. So thank you. Carol's first question is, I have a question about committees. The VP of my HOA is and when I stress a word, it's because the word is in all caps. Okay. So the VP of my HOA is the person for landscaping. He decided that he doesn't want me discussing anything with the landscaper and that he is the only one that is allowed to walk around with the landscaper. He controls who can be involved, blah, blah, blah. He is the committee and he is the only one on the committee. Is this allowed? We are 41 homes. So I guess the question is a one-person committee a committee?
I mean, it's
And
not really a committee. The question is whether that committee is even required. If it's an architectural committee, then yes. Generally speaking, there needs to be more than one person on that committee to make the decisions. But I mean, it's 41 homes. How many people do you think you can actually get to serve on the committee? But if it's just Robert's rules generally won't apply, by the way. There should be a not number of people on a committee, but if you're saying it's only two, they really should be appointing one more. But if both of them agree, who cares that there are only two? The purpose of having an odd number is so that you don't have deadlocks. And if the two are agreeing on everything, then you've got a vote of a majority.
but Alan, aren't committees, aren't committees really a way of recommending to the board? I mean, it's still the board that ultimately has to make the decision, no?
Depends on what the situation is. I mean, if you've got an architectural control committee that makes decisions, then they make the decisions. If
Okay.
you've got a committee, remember, we talked about two different types of committees. They can
Yeah.
be court appointed or they
Yeah.
can be more statutory. The finding committee does not report back to the board other than the results,
Okay.
and the finding committee makes the final decision. So
Okay.
There are some committees that do actually make decisions on behalf of the association. Some of them decide to spend money. That's why we say those particular types of committees need to have open meetings just like the board, because they're
Okay.
operating in place of the board for specific aspects of the operation and maintenance of the community.
So I guess that's where the term advisory committee comes in.
Right. An
Okay.
advisory committee says, we think you should do this.
Right.
Other committees say, we're doing this.
Okay. And just for the record, we both did know that. I just wanted to point that out to make it clear for everybody here because that is another one that comes up all the time. Please clarify member email addresses available to membership or only directors.
So again, if it's a member email address that is used for serving official notices, that is open to all of the members. If it is a member email address that they've only designated to sign up for the portal for email blasts that go out to all the members, basically, hey, here's there's a meeting coming up next week, but it's not an official notice of the association, those are going to be something that are not subject to inspection by the members.
Okay, I'm going to scroll down for one just to get one near the bottom because we're out of time. So, let's see here. I'm new to the board. Other than the annual and budget meetings, do we really need to have a monthly ACC and HOA meeting?
You should, but you don't have to. I mean, I get not wanting to have a meeting once a month, but I can't imagine what you're doing within your community that you don't need to figure out what's going on at least once a month. At least quarterly would be my recommendation. But for the architectural committee, especially, some community declarations say that you only have 30 days to make a decision, yay or nay.
Yeah,
So if you're only having a meeting once a quarter or twice a year, you're guaranteeing that some of those are automatically approved. If your documents don't say that, good for you, but you're also not serving your members in the way that they should be served if they have to wait, 3 to 5 months to find out whether they're allowed to put this thing on their lot. And a lot of them are going to say, screw this, I'm not waiting. I'll go ahead and do it. And if you want to come after me for violating, have at it.
understood. Understood. And Alan, I know you have to run. Michelle, if you're still there, if you want to come on back in, give some parting words. I'm going to remain on. Alan, by the way, great job as always. I always enjoy doing these with you. Michelle, thank you so much for having us. And Michelle's going to give some final words. And even when the two of them head out, I'm going to remain on and help. The chat is now open for technical questions. I may have the answers, but I cannot answer attorney related questions. So in the chat, you can ask me techie questions about the evaluation, certificates, this class, what we have coming up. But for now, Michelle, please let everybody know some parting words from the fine folks over at Sentry. Thank you for having us.
Thanks so much. See, I told you it would be a treat. This was wonderful. Wasn't quite the full 3 hours of content. Got a lot of Q&A in. We love working with you guys. We hope everybody on the call agrees. Again, thanks for taking time out of your day. I'm just going to put 2 pieces of info here. I'm going to mention again for those Sentry board members, your certificate, when you receive it, is for your records. We're going to get those too. We'll upload them into the official records for your association. They'll be in the portal if you want to verify that they're there
There's
within
that
about
portal word again.
I know, right? Within about 10 to 12 days. So I'll go with that too. It does usually take us up to 2 weeks to get those out there, but that's what we do on our back end to try to help your CAM and not having to manage all the emails back and forth.
Yep.
I would say another thing, I saw a few questions having to do with the CTA filings. If you're a board member in a Sentry managed community and you're working on submitting that info through our service that we're doing, please feel free to reach out to our team. We're assisting our board members with that. Our email is learning@sentrymgt.com. We're happy to help out as you go through that process. We have some resources and things available for that for our board members. With that said, Alan, Jeff, you're wonderful. Thank you so much. We love working with you guys, and I'm sure we'll work again with you soon.
Let's do it.
Looking forward
Pleasure.
to it. Thank you all. Jeff, I'm sorry. Let me just
Sure.
get my parting words so I can prepare for another webinar I have next week.
Absolutely.
Another group. Thank you all for being here today. I appreciate we still have over 100 people that are listening to us, believe it or not. So very kind of y'all to stick around. I hope you got a lot out of this. Again, if you need anything, if there are questions about what I said during the presentation, I may not be able to answer them without referring you to your attorney, But if you need any help, it's very easy. as@kbrlegal.com is going to be the easiest way to reach me. Thank you again to Sentry. Thank you to Michelle in particular, and y'all have a great day.